of next week for us, please. That would be,
But then there's going to need to be potentially responses.
yeah.
Back. So maybe we're why don't we look at, can everybody get everything done even if the timelines are shortened by the 18th or 17th of November?
Yes.
Well, say the 18th.
Yes.
Isn't that a Saturday?
We're gonna need them. I can clean up my pleadings too, because I do
Okay.
think there's,
Oh, no, it's.
so why don't I go, do you want me to go first?
On,
On cleaning up the pleadings, because I think on the landlord side, there's some cleanup to do as well.
okay. I mean, you know,
Because I don't want you to respond to what's on there currently. I think,
okay. Good.
What just happened?
I think that the landlord would like an opportunity to clean up the pleadings on the landlord side, so we should probably go first. And then the tenants are responding to the most recent pleadings.
All right. So how fast can you do that?
I can do that the week before the 18th, Your Honor.
The week before the 18th.
So that would
Then
be,
you need time to respond to that.
We,
So what's
and there will be a
next?
counterclaim,
Pardon?
and then we may have a counterclaim, you know,
That's what I thought.
yeah.
okay.
So, it's my next date after the 18th. Okay, so if the landlord has everything in order by the 17th, any responses, counterclaims and the like would then need to be addressed within the next 2 weeks after that,
Okay.
It's December 1st, something like that.
by December 1st. And then what I would do is I'll set another pre-trial final settlement conference December 2nd. Just because we have to make sure everything's in order. To have that. Go ahead, Mr. Miller.
If we file on December 1st and there's a counterclaim, we won't have an answer to that at that point.
Correct. Oh, I'm well aware of that.
Okay.
I mean, I get it, but if I put it further out, then you're gonna have to answer. What I may end up doing is saying you have to answer the counterclaim by a certain date, a trial date.
Okay.
That kind of makes sense. I'm just trying to get everything back on track
Mhm.
so that we know exactly what we're dealing with, because we didn't. Now, the one wild card in all of this is I'm not sure what Ms. Hope will do with all of this. Because some of the claims, I think, from the landlord are going to potentially involve her, or maybe the counterclaims are going to. So I think it's probably better that we have that pretrial, because she's going to, I would imagine, have to respond to some of that. If that makes sense.
Yeah, I don't think we are planning a counterclaim that would be directly against either Donna or Cambridge. As a party. Now, she may be a.
Right, but but the problem's going to be that the counterclaim, so the initial claim is going to involve certain things. Your counterclaim would then come,
Yes.
but then the response to that counterclaim, I can imagine, at least knowing what I know about the case, may involve some of the actions of this code.
Okay.
That's
We'll deal with it when it arises.
And you also filing the motion.
and how I've handled
That
this.
you want
So,
back.
Now, so how would you visualize this interacting with the motion we'd like, just to clarify Ms. Tope's status?
okay, so what I'll do is I'll set a final settlement conference for December 2nd. Any motion you'd like to clarify the rights of the parties, I would need filed with an opportunity for the parties to respond. So you need to file that in time for them to
In time.
respond, and then I can rule on that
So you'd
On that
still-
same day?
on that same.
You're arguing it on the second.
Yes.
Okay. So the second at 9 a.m. for final settlement conference and to argue any motions.
Yes. And then from there, once everything's cleaned up, then I can give you a clear trial date and see exactly
Good.
where
Okay,
that makes sense.
Thank you.
thank you.
I really want to say you're welcome, but
No. We have a direction now. We know where we're
Yes.
headed. And
all
I
right.
Thank you.
Thank you.
Thank you, Your Honor.
I Well, no, I did, but it's over here. Yes, got it. What is, are they adjourning? Where, what's watching? Court does call the cases of the people of the state of Michigan versus Christopher Minor.
Trevor Ray, up to the people, good morning.
Good morning, sir.
Assistant Public Defender Sandra White on behalf of Christopher Minor on 25 F1 5195 and 25 F1 5241.
Good morning, Your Honor. Jay Grant Miller, P 58658 on behalf of Mr. Minor on the third case.
And what are we doing?
Your Honor, we're asking for an adjournment on these matters.
Your Honor, I was appointed at about 7 o'clock last night. I haven't
You're
even,
not ready? No, go ahead.
I haven't even gotten all the discovery to download fully to even know if it's complete yet. So
You want these cases to all travel.
I think it makes the most sense from talking with counsel here that they all seem similar in nature and possibly a universal resolution may be possible in this matter.
No objection from the people.
Correct, Your Honor.
Preliminary examination will be adjourned to November 18th, 2025, 9 a.m. before Judge Washington.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Bond will continue. Let's call the case People versus DeMarco Henderson.
County Water Assistant Prosecuting Attorney for the People. Alex. This is a waiver.
Your name, sir?
Marco Henderson.
It's just here. Mr. Warren Green.
Yeah, they start. Yeah, you said.
Lauren Brown, Deputy Chief Public Defender, been written on behalf of my client. Please state your name for the record.
DeMarco Henderson.
All right. This is a waiver.
Yes, it's my understanding that my client wishes to waive his right to hold a preliminary examination and agrees to be bound over to circuit court.
Sir, is that correct?
Yes.
All right.
I wanted the other guy that I spoke with him in the hallway. I spoke with.
He's right there.
There he is. I didn't know if we all had the same understanding, so I didn't.
Pardon?
So I didn't know if he had the same understanding as he did.
He has a greater.
Probably not.
Yeah.
Morning, Your Honor. Alex Warren Green on behalf of Mr. Henderson. Mr. Henderson, can you state your name if you haven't already?
No, I already did.
He already did. We go way back now, waiting for you.
Your Honor, we provided the court with a signed preliminary examination waiver. At this time, Mr. Henderson does wish to waive his right to a preliminary examination. We are continuing our negotiations with the people and we'll be squaring away the details as we approach his circuit court pretrial date.
Sir, is that correct? You're waiving exam?
Yes, sir.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their
Yes, Your Honor.
preliminary examination having been waived. Defendants bound over to circuit court on both counts. Mr. Warren Green.
Your Honor, we acknowledge receipt of the information, waive its reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
December 22nd at 1:30 with Judge Moody.
December 22nd, 2025, 1:30 before Judge Hamoud. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
There's there. Court does call the case, People versus Michael Siegel.
Prosecuting attorney for the people.
Good morning, Your Honor. James Fifelsky on behalf of Mr. Siegel, who's approaching. Can you state your name, please?
Michael Anthony Siegel.
Thank you.
Your Honor, my client will be waiving preliminary examination. It's my understanding the prosecuting attorney will not or will agree not to file an habitual notice in exchange for the waiver.
That is correct, Your Honor.
Sir, you're waiving your right to have a preliminary examination?
Yes, sir.
Understanding that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Okay.
You understand that?
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. 5,000.
Your Honor, waive formal reading of the complaint and or information and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
November 12th at 1:30 with Judge Conlon.
November 12th, 2025, 1:30 before Judge Conlon. Bond will continue. Thank you.
11:20.
Take care.
Have a good day, Judge.
Thank you, Judge. Thank you. Don't know. All right. Well, why not? I can do civil and criminal all at once. It's schizophrenic before. Oh, dear. Pasco called. I'll talk to you. All right. Clark Road Family Dividend Housing versus, is it Deschanay Baker?
Good morning, Your Honor.
Good morning.
We do have two witnesses. Would you like them to remain there or
Pardon?
where would you like my witnesses to come?
They can wait where they are.
Over there? Perfect.
What are we doing?
Okay. Your Honor, we've already,
I'm sorry, where am I supposed to go?
right here.
Right here.
We're a little crowded.
All right. State your name.
Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Your name?
Deschanay Baker.
All right. What are we doing?
Yes, Ms. Baker has already provided possession. So today was just an issue of money damages that were requested.
All right. And you're unable to agree on that figure, is that?
No, sir. Correct. We do not have an agreement, Your Honor.
Not have a fee.
Correct.
How far apart are the parties?
I haven't spoke with anyone from the property since I've turned my keys in, so I haven't been able to come up with an agreement from anyone.
Your Honor, if I
Go
may,
ahead.
the defendant has indicated that she has had habitability issues. It's my client's position that there was no habitability issues, and she is requesting damages in the amount of hotel bills that we did not receive, as well as, again, indicating a habitability issue. So we are very far off.
Your Honor,
would you like us to speak in the hall momentarily, Your Honor?
I probably would, but hold on. What were you gonna say?
Your Honor, I'm not asking for any money in return. I'm just asking for the charges to be dismissed and for no eviction to be on my record.
Okay, I understand that last part. What is the total amount of plaintiff's claim?
Including court costs, it would be $3,055.63.
And ma'am, but the court's understanding you disagree with that because you weren't in the premises?
I disagree with that upon many factors. In the landlord's response to my counterclaim, it includes a statement that on August 6th, I denied entry to maintenance and they could see the fan because of the entryway. That is not true. I have proof that I actually asked management to meet in the leasing office to discuss my concerns, and the manager refused to meet me there. She chose to come to my apartment instead. This shows that I wasn't denying access to them. I was just asking to talk in a proper and safe environment to resolve the issues that I had, not only with just the leak and the mold and my pet dying in regards to everything going on in my apartment.
Majority of your claim, how much of that is rent?
$2,207.
I'm sorry, there was a sneeze. 2,000.
$2,207 for rent, $90 for the washer and dryer rent. Legal fees was $239.40. Additionally, there were unpaid utilities of $94.23.
Unpaid utilities.
Correct, Your Honor.
Okay.
And we do have the bills from DTE and consumers regarding that. And then, or I'm sorry, I think it's just DTE. And then the damages was the amount of $425. And that does reflect a cleaning fee. There was a secondary repair with the drywall due to tenant caused damage. And just a moment. And then there was a bulk fee where they had to remove bulk furniture from the unit after she moved out. And then there was also a replacement of the disposal system due to tenant caused damage.
Yes, upon me moving out, there was nothing wrong with the apartment. With me leaving, the disposal working.
Hold on, man. Were you in a hotel or not?
I was staying at family, friends, and relatives. I'm currently couch surfing. I don't have anywhere to stay.
Well, okay. I mean, during this period in time, were you in the unit?
During this period of time, I was not in the unit. I was staying at a family friend's house.
Had you notified the landlord of that?
Yes, I did.
In writing?
Yes.
I submitted them. Writing?
I submitted a paper in writing stating that I would not be paying rent, that I wasn't staying in the property.
I understand what you're telling me.
Mm-hmm.
Do you have a copy of what you gave to the landlord?
Yes.
All
right. Have you shown the landlord that?
Yes, Your Honor. The defendant also refused entry for repairs during that time without her being present. And so our argument is that she failed to mitigate the damages. Additionally, repair was made that same evening to the leak in the ceiling that was caused by the HVAC system above her unit. So it had leaked through. She called in sometime after hours. By 10:30, 11 o'clock that evening, we have maintenance here on site to provide testimony that they provided immediate repairs, including fans. Within a week, they had a professional carpet company out there that provided additional remediation, including repair or cleaning the couch and the rug. And the repair itself was completed by the 19th.
Your Honor.
And this occurred on the 5th.
Your Honor, that's not true. On the date, I was at work that they came to repair the apartment. Maintenance.
Ma'am, let me ask you this. Did you let them into the unit?
Yes.
To make the repairs?
Yes. The date that she mentioned, I was not home. The maintenance guy called.
Are you disputing that they made the repairs?
No, I'm not disputing that they made the repairs. They did enter my home and make the repairs.
Okay.
On the 19th, after the leak happened on the 6th. They did not reach out and let me know when they were supposed to come. I had got no notification when the repair was supposed to be made. I had went up to the office multiple.
So, but why would that,
I'm sorry.
why would that matter?
What's your question? Why would what matter?
You called in a leak. They came and fixed it. We're all in agreement on that.
They did not come. I called in the leak. No one communicated with me. I called in the leak the night that it happened. 2 employees came and he pulled out where the leak had came from because they said that they had not fixed or changed the filters out. The filters were supposed to be changed every 6 months. I had been living there for 9 months and nobody came.
That's fine, but you called in a repair. What you're telling me is that they came out that night, right?
They came out that night and put a blower in my house and just told me to leave it on the ceiling and on my furniture that had been ruined. Yes.
But
the leak was not fixed that exact night.
okay, but they don't necessarily have to fix it. They tended to what your complaint was, right?
Correct.
And then at some point within those next 2 weeks, they fixed it. You would agree, right?
No, it was not within 2 weeks.
I thought the 16, 19.
Your Honor, the drywall took additional time.
The drywall.
The drywall took additional time.
But the leak was fixed.
The leak was remedied. And then once the leak was confirmed, they did wait, I believe, a couple of weeks to confirm that the leak was finally fixed.
Final.
And they had a
The
third
drywall.
party, correct, and they had a third party drywall company come out to provide repairs. At that time, once the repairs were complete, the tenant did, or the defendant did come back home. There was wet paint from the repair and she proceeded to poke a hole back through the ceiling. That is where the charge came from. The property did not charge her for the initial drywall. They charged for the secondary repair because she poked a hole in, alleging that it was moisture from the leak that had not been an issue for several weeks.
Did you do that?
Maintenance had previously told me that if a
Okay, hold on. Now, you need to answer my question. Did you put a hole back in the drywall?
No, I did not intentionally put a hole back in the drywall. I allowed the water to flow into a bin instead of on my couch.
After they made the repair?
Yes.
What date was that?
19.
Your Honor, we have a photograph of the hole in the ceiling that indicates it's over the door. There's no couch underneath that photograph.
Your Honor, the hole where the leak had happened, my furniture was there. They had, in their counterclaim, said that I denied them entry and that I damaged their property. I was just trying to get my problems resolved so that I could leave the property voluntarily. I was reaching out to compliance and upper management to discuss.
This rent is for what period?
It is for the period of July, August, and I believe part of September.
I moved out September 17th, right after our first hearing.
And the leak occurred when?
August 6th.
And why wasn't July paid?
July wasn't paid because I discovered black mold in the building.
Your Honor,
in the building?
Yes. Throughout the building, there was black mold.
Was there black mold in your unit?
No, sir. There were immense other problems that I was facing while living there that contributed to me not paying rent.
How then you weren't paying rent?
Huh?
In August, we received, or my client received notification in August after the repair had been partially made and the drywall was pending, indicating she was not.
How long, when did you move in?
I moved in January 24th of 2021.
January,
but they,
January, February, March, April, May, June, you paid rent.
yes, on time every month.
So the black mold came in when?
In July.
All of it?
Yes.
It just appeared.
The black mold, it came from an apartment that was also leaking water on the first floor. There was also an apartment leaking.
So
water
the
on
black, hold on, the black mold just started to exist in July?
The black mold did not just start to exist in July. It's when I became aware of the problems that not only I
So
was
when
facing,
you
but the other
didn't pay
tenants.
July, did you tell them this is why I'm not paying my July rent?
No, Your Honor.
Then you've got a problem. Even if true, which I have my doubts. So what I'm going to suggest you do, and then is why don't you take a moment to talk
Yes, Your Honor.
and see if you can resolve it. I will let you know that I'm seeing certain problems with what you're telling me regarding any type of solution to this in terms of the monetary amount. But we can all have our positions. I'd suggest that you talk with counsel and see if you can work it out. If you can't, then I'll take you back and we're going to work it out.
Okay.
Thank you, Your Honor.
But I don't know that you really want to talk to me today, but I'm always happy to talk to you. Thank you.
Thank you.
Thank you, Your Honor.
Sorry. He's not right there. Okay, court does call the case, People versus Nathaniel Lucas.
Your Honor, may 10 months of custody and not
Assistant Public Defender Natalie Pate for Mr. Lucas, who is not present, Your Honor. He is in custody at St. Joe's Hospital.
And
So we need to go there.
Hey, I'd be down for a field trip.
Road trip.
In light of that, I did speak with Ms. Tanha briefly, and she did seem to indicate that people would be able to proceed today. Given that and that he is in the hospital, I would be asking for an adjournment of the preliminary exam.
Your Honor, that's accurate. People have.
So what'd you say to the adjournment?
I'll leave it to the court's discretion.
Okay. All right. Is there anticipated a time that he may be, or?
Frankly, Your Honor, I don't know. What I do know is he was not in the hospital on Friday, but yesterday morning at 8:40 a.m. when I went to visit him, he was already in the hospital. But they could not tell me when he went or what his issue was.
Curious.
Because he left me a voicemail not in the hospital Friday afternoon at 2:30. So something happened.
So he was in the jail.
Yes. So something happened
Well
between
enough to
then.
call you on Friday.
Mm-hmm.
And then at some point between Friday and
Yesterday at 8:40 a.m. Yeah, I don't know. For all I know, he broke a bone. He has an infection. I hope he's all right.
Will be clarified once we see the documentation.
well, glad I don't have to be part of that. All right, so here's what I'm going to do. I'll adjourn the preliminary examination.
Thank
I'll
you.
adjourn it to November 18th, 2025, 9 a.m. That will be before Judge Washington.
Thank you, Your Honor. Excuse me.
Bond continue. I should have done that for today. People talk to me on Friday and then I could just say I'm not here. Oh, no. Zary, don't call them. Is there a case up here? Just ignore her. Court does call the case, People versus James Hagan.
Rob Dowd, Assistant Prosecuting Attorney on behalf of the people.
And Assistant Public Defender Natalie Pate on behalf of Mr. Hagan, who stands to my right. Please state your name for the record, sir.
James Hagan.
Thank you.
And Your Honor, pleading a separate preliminary exam that people are unable to proceed.
Motion to dismiss, Your Honor.
People being unable to proceed, this case is dismissed on defendant's motion. That's without prejudice. Thank you.
Thank you, Your Honor.
Court does call the case of the People versus Jessica Hapner.
Rob Dowd, Prosecuting Attorney on behalf of the people.
Real on behalf of Ms. Hafner. Just please take the record.
Jessica Hafner.
Good morning, Your Honor. Today's the date and time set for preliminary exam. The people have tendered an offer whereby Ms. Hafner would plead no contest to child abuse fourth. We intend to take the people up on that offer. The court should be already in receipt of a sentencing judge waiver as well, and the plea form, as well as a copy of the police report and her assigned advice of rights form.
Plea form I have indicates that the defendant will be pleading no contest to the charge of child abuse fourth degree, the 1 year offense. Upon successful plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement. Is that correct, counsel?
Yes, that is correct.
That's correct, Judge. Count one is the child abuse.
May I have her sworn?
Raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Jessica Hafner.
Ma'am, it is this court's understanding that you're going to be pleading no contest to the charge of child abuse in the fourth degree. That's a misdemeanor punishable by up to 1 year incarceration and up to 5 years probation. Do you understand that?
Yes, sir.
Do you understand what a no contest plea is?
Yes.
Do you understand what it is?
Pardon? I'm standing mute, not saying guilty, not saying not guilty.
All right. A no contest plea means that you're not contesting this charge. You understand that?
Okay.
41714. Present before the court is Ms. Fishburne, right?
Yes, Your Honor.
And Mr. Harrison, the prosecutor's office, Officers Cal and Martinez from probation. We're here today for a final violation hearing. You did already admit to this, and when we talked last, you did not want to be represented by a lawyer. Is that still true?
That's correct.
All right. So what's our thought on this, Officer Cal?
Your Honor, at this point, based on conversations with Ms. Fishburne, she had told me that she would either like to go back to the Recovery Works program. If she's not able to do that, she would prefer to do a prison sentence. I did reach out to Recovery Works. They are willing to accept her back, so I believe an appropriate sanction, if we allow her to do that level of care, would be to revoke the ILC. And then in speaking with Officer Martinez, we believe she would be a good fit to transfer back to the mental health docket at this time.
Mr. Harris, state a position on this?
I will defer to the recommendations of probation, Your Honor.
Ms. Fishburne, what do you want to tell me?
I would love to go back to Recovery Works. This is cliche, but I think I learned my lesson. I just want to do my best in life, and I am trying my best. But if that's not the case, and I'm not allowed to do that, I asked for prison, just because I know Recovery Works, and I like it, and it fits for me. I've been to a lot of programs, but that program speaks to me. You know, I enjoy the workers and the people there, the environment. And I don't want to keep guessing on programs, if that makes sense, and then just ultimately end back here if they don't work. So that's why I asked for prison, so I don't just slow walk back here. Ultimately, I would like to get out and get a job and, you know, be in Recovery Works and maybe 6 months down the line, you know, graduate and start a normal life that doesn't include incarceration. So with that being said, that's my point of view.
So I'm in a bit of a box here, Ms. Fishburne, and I'll tell you why. When I put somebody on probation, they don't tell me how to supervise them on probation. It just doesn't work that way. And the fact that you're taking the position, you know, I want to go to Recovery Works or else, two things. Number one, I don't like being told what to do. And number two, I don't think that you're in a position to set yourself up for success when you say, you know, this is what I want to do, and if I can't do that, then just send me to prison. You know, first of all, you have no idea what you're talking about. When you say send me to prison, you don't know what the prison system is like. I've been doing this for almost 20 years now, and the Ohio prison system is horrible. It has nothing to do with rehabilitation. And the people that you would meet when you go to Marysville are the worst people that you would ever meet in your life. So you have no idea what you're talking about when it comes to that sort of stuff. And secondly, this is not a prison case. Stealing stuff from TJ Maxx and in a stolen car, that is not the kind of stuff that we send people to prison for. But I don't like any of this. I don't like your attitude. I don't like the way things have been going on probation. We've had a bunch of violations so far. But the reason that I'm in a bit of a box on this is that Officer Martinez thinks that Recovery Works is the best thing for you. So you demanding what is the best thing for you, I really don't know how I feel about this. And I have to tell you that my inclination is to sentence you to 180 days in jail and give you credit for the, what?
48 days.
48 days that you have already done, and you can just serve out the rest of your time in the local jail.
Can I respond to that?
I'm sorry?
Could I respond?
Sure.
Your Honor, I didn't mean it as an ultimatum.
How can I take that any other way, Ms. Fishburne?
I'm sorry that it came across that way. That's not how I meant it, because I know I have no power in my case right now. I just had a lot of time to think, and I think those were the situations I thought I would do best in. So, you know what I mean? Just like they had their recommendations, those were just mine. I understand that I have no say-so in the matter at all. So I'm sorry that it came across like that. That was just what I was asking for, if that makes sense.
Do you know why we send people to places like Nova or Genesis or Recovery Works? Do you know why we send people there?
Because they want to do the right thing and succeed. And
Right.
put their lives together.
And then what's the basis of that then? Why do I send them there? Because the decisions that they make in their life, Ms. Fishburne, are wrong. When you're out in the community and you think to yourself, you know, I should do something, and I have two choices in front of me. The history of Carmen Fishburne is she picks the wrong thing. I mean, you would agree with me on that, right?
Yes, I know.
And so then for you to sit in the jail or sit here and say, you know, I've weighed out the options in this case, I've had a lot of time to think about it, and I'm going to choose Recovery Works because I think that's what's best for me, when the reason that I'm sending you to Recovery Works is so that you can reevaluate the way that you make decisions and make better decisions that are going to set you up for success. And I don't really know, but I interrupted you, so go ahead.
That's all I had to say, Your Honor.
Officer Martinez, you would ultimately be supervising Ms. Fishburne. Tell me why I should do this.
Well, like you said, Carmen Fishburne has made very poor decisions, and we can look at her criminal history and we can see that. We can see the violations that she's had on probation thus far. However, there is a part of her that shows that she does want to make better choices. I don't know if Carmen Fishburne knows how to make better choices, and so that's where probation comes in. I would like to sit down with her and break down those choices so that we can start making better choices in the situation she comes across throughout her recovery and hopefully moving forward in her life. Ultimately, I think without probation's intervention, I think Carmen will continue to make poor choices and she will continue to be in the court. I would like to see Carmen successful. I think she has what it takes, but she needs guidance and direction.
All right, I am going to revoke your intervention in lieu of conviction. I'm going to sentence you to 3 years in our community control program. I'm going to put you on the mental health docket. You're going to enter into and successfully complete the Recovery Works program, plus any aftercare and additional requirements that they have. I'm going to delegate to Officer Martinez the ability to make special or additional conditions as they see fit. And I'm going to place you on 60 days of electronically monitored supervision with a curfew. I'm not going to impose a fine. I am going to impose the costs. If you violate the terms of your supervision or you leave the state without permission, I can sentence you to up to the maximum penalty in this case, which is 18 months in prison, plus the optional period of post-release control of up to 2 years. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. You don't have the funds to hire a lawyer, to obtain a transcript, or to pay the costs. Those will all be provided to you at no charge. Ms. Fishburne, this is a big day for you because your life almost went in a different direction. And I hope that you make the best of it because, believe it or not, I want you to succeed on probation. The worst thing that could have happened to you today is that I sent you to prison for 18 months. And maybe someday you'll have some appreciation for that. Certainly not today, though. All right, that's all. Credit for 48 days.
And there was a restitution order originally. I'm not sure if that's been paid. It was $210 to Jacob Roney, Groene.
All right, yeah, the restitution figure carries over. All right, good luck to you, Ms. Fishburne.
Thank you.
Thank you.
Let's do a probation review in 90 days.
You understand that, ma'am?
Yes, sir.
You understand also that what I would do, and I have reviewed the police report in this matter, and I would accept the facts in the police report as true to determine whether or not this crime was committed. You understand that?
Yes, Your Honor.
All right. You understand that for the purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. You have any other questions regarding a no contest plea?
No, Your Honor.
So do you think you understand a no contest plea?
Yes, Your Honor.
All right. Basis for the no contest plea?
Potential civil liability.
All right. Ma'am, you do understand that you'll be sentenced before Judge Washington in 14B District Court, although I'm taking your plea.
Yes, Your Honor.
All right. So, ma'am, to the charge of child abuse, 4th degree, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty or pleading no contest, you're giving up those rights as well as all the rights on there.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
Court has been provided and has reviewed Washtenaw County Sheriff's Office report for their case number 24-96798. Any objection to the court having reviewed that report?
No, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of the offense. Ma'am, I do have to advise you that if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rule, you would first of all not be entitled to any evaluation or recommendation. The court would no longer be bound by that, and you would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Judge.
No.
Has the court complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes.
You have and it would.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
December 11th at 10 a.m.
December 11th, 2025, 10 a.m. before Judge Washington.
Thank you, Judge.
There is a motion to modify bond.
Yes, Judge, it should be a stipulated order.
Stipulated order.
Yes,
this is what we discussed the last time.
Yes, Judge, and it reflects the language, including the case number from the neglect abuse docket.
Very good. Bond will continue with that modification.
Thank you, Judge.
Court does call the case. People versus Brent. Is it Hackbar?
Good morning, Andre.
Morning, Your Honor. Good morning, Honor. Dan Garrett on behalf of Mr. Hackbarth.
Brent Hackworth.
Your Honor, we're asking, I think, maybe it'd be a joint request for adjournment. If not, it could be ours. There's a substantial amount of discovery that we requested that was just coming through this morning. I need to review that and go over that with my client. I don't know if Judge Washington's next exam date, Your Honor.
Why, you don't want me?
I want you,
He
yes.
specifically asked for Judge Washington.
You did?
There's reasons for that, Your Honor.
Wow. Wow, really? I'm hurt.
No.
I'm hurt. No, you know how sensitive I am. No, I'm sensitive. I'm pouting. All right. She did? She set aside time? Yeah. And they're messing it up? Yeah, I was messing it up. All right. Next date, I understand that Judge Washington has some involvement, has done this, so I don't have a problem with it, although still hurt. Her next date is November 18th.
Oh, we're going to make that work, Your Honor. Thank you.
Sure. You can do it at Costco's. No, I'm kidding. You know I'm never gonna let that.
Apparently not. No.
Ever let that go. Will that work for you? I don't know what, excuse me, what's her date after that?
So December 9th would be the next date.
Let's just keep it the 18th, Your Honor. I know she normally does a little bit later in the morning.
That works for the people. All right. Preliminary examination will be adjourned November 18th, 2025, 9 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case. People versus BJ. Is it Pudell?
Good morning, Your Honor. Ken Hess, the prosecuting attorney of that.
Morning again, Your Honor. Dan Garrett on behalf of Mr. Podell, stepping forward. State your name, BJ. Please. State your name. BJ Podell. Thank you.
Your Honor, this is the date and time scheduled for preliminary examination. However, people are unable to proceed with the felony counts, like counts 1 and 2. We'd ask for remand to district court on count 3, malicious destruction of personal property, 200 or more, but less than 1,000. As well, the district to add count 4, aggravated assault that is 0H1A. That's a 1-year misdemeanor and or $1,000 fine.
I'll need a new complaint filed. That's ag assault. Can you give me that pack code again, please?
Yes, Your Honor, it's NCL 750-818.
Thank you. All right. And as to the added count for your client waives any reading or presentation?
He does, Your Honor. Thank you.
And he stands.
He does.
Court will continue to not guilty plea as to count 3 and enter plea of not guilty to count 4.
And then there would be a formal motion to dismiss counts 1 and 2 as the people are unable to proceed.
Counts 1 and 2 are dismissed. Set this matter for pretrial.
November 19th at 9 a.m.
That work for?
That's here.
Yes.
Yes. Perfect.
November 19th, 2025, 9 a.m. That is before me.
Thank you, Your Honor.
Bond will continue with its conditions.
Thank you very much, Your Honor.
Court does call the case People versus Jeffrey McCullough.
Assistant Prosecuting Attorney.
Good morning, Judge. Christopher Quinn appearing on behalf of Mr. McCullough, who's present.
Jeff McCullough, Your Honor.
Thank you.
As the date and time set for preliminary examination, at this time people are unable to proceed.
For dismissal, Judge.
People being unable to proceed, this case is dismissed. The defendant's motion that is without prejudice.
Thank you.
Thank you. Court does call the case of Strong Future Homes versus Chanel McFarland.
Morning, Your Honor. Tish Lee on behalf of Ms. Chanel McFarland.
Good morning, Your Honor. Parissa Gazari appearing on behalf of plaintiff.
Good morning. I have before me a conditional order of dismissal.
Yes, Your Honor.
Court having read, I'm satisfied certainly with that, and both sides being represented by counsel. I don't need to make further inquiry. This case is conditionally dismissed, and I signed your order.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case, People versus Edward Harris.
Trevor Mabel for the people.
Vaughn Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Edward Harris.
Hey, can you hear me, Mr. Harris?
Yes, I can, Your Honor.
All right, very good. All right, I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of larceny less than $200, the 93-day offense. Upon, that's a count 3. Upon his successful plea to that charge, counts 1 and 2 would be dismissed. The defendant is also agreeing to pay restitution in a total amount of $130 without a restitution hearing relating to the victim of Natalia Lovo. And that's specifically as to count 1, but he's agreeing to pay that amount. There's also the prosecutor and defendant are agreeing to a sentence agreement of 93 days of jail credit for 42 he served. There's a note that the defendant is incarcerated at the Washington County Jail as a result of being sentenced on other cases with an estimated release date at this time of March 3rd, 2026. That's the court's full understanding of the.
That is our understanding as well.
That's accurate. All right. The one thing I will do on the form without objection is I will check the sentencing judge waiver box. This is not my case.
Without objection.
All right.
Thank you, Your Honor.
Thank you. All right, you ready?
He's executing the
I thought he was writing warrant.
Device of rights.
Yeah, have him sworn.
Raise your right hand. Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name. State your name.
Edward Harris.
All right, Mr. Harris, it is this court's understanding that you are going to be pleading guilty to the charge of larceny less than $200. Is that right?
Yes.
That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be the sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. Do you understand that?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Right.
Okay, you signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights?
No.
All right, look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up all of those rights?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
All right. Are you on probation or parole?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
All right. On the date of May 3rd, 2025, at the location of 530 South State Street, City of Ann Arbor, Washtenaw County, State of Michigan, what do you do that makes you think that you're guilty?
What was it I did over there? Oh, I had committed larceny out of a building.
Okay. So did you take something that wasn't yours?
Yes.
What'd you take?
What was it? Backpack.
You took a whole backpack?
Yes.
Okay. And that backpack wasn't yours?
No.
And the owner of that backpack didn't give you permission to take it?
No.
And at the time, you wanted to keep that backpack permanently in some way. Is that correct?
Yes.
Okay. Okay? Okay. All right. Sir, I do have to let you know that if I accept your plea, between the time of my acceptance of your plea and your time of sentencing, that if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence recommendation or evaluation. And you would not be entitled to withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other actions which have led to this plea?
No, Your Honor.
Would it be, have I complied with the court rule, and would it be proper to accept this?
I believe so, Your Honor, yes.
Yes, Your Honor.
Court, well, you okay?
Yeah, this one.
Okay. Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
November 21st at 8:30 a.m.
November 21st, 2025, 8:30. That's before Judge Perry. All right, Mr. Harris, is this the last case you have before me?
Yes, it is.
Is it?
Yes.
Well, great. I wish you, Mr. Harris, you have been an absolute joy. All right.
Thank you.
Always very respectful in terms of the way that you approached, and you got a good heart.
Thank you.
Okay. Just don't take any backpacks.
I won't.
You won't? You won't do that anymore?
No.
All right. But I wish you all the best, since it's the last time I'll see you.
Oh.
I better be the last time. Don't do anything else to come back.
It will be.
All right. You take care of yourself.
All righty. Thank you. Your Honor.
And we'll continue.
Thank you.
Wish I could have said the same nice things about his attorney, but nah. Court does call the case of the people versus two cases, people versus Beverly Joe Tuttle.
John Overwater, Assistant Prosecuting Attorney for the people.
Good morning, Your Honor. Wendy Barnwell, P42505. On behalf of Miss Beverly Jo Tuttle,
My apology.
we are both here.
Good morning, sir. Beverly J. Tuttle.
That's time set for preliminary examination. This time people are unable to proceed on either matter.
When we move to dismiss on both cases,
People being unable to proceed, these cases are dismissed on the motion of the defendant. That's without prejudice. Thank you.
thank you, Judge.
Have a blessed day.
Oh, wait, is that for this? Is that for these?
No,
cases?
no.
You don't like it when I call you Beverly Joe, do you?
I can't stand that name.
Huh?
I can't stand that name.
Why? That's your name.
I didn't have a choice in it.
Okay, all right. You take care of yourself,
Have a blessed day.
Beverly Joe. Is council ready on? Yeah. Were we ready on Clark Road or? I'm so happy. I don't know what that. Court does recall the case of Clark Road versus Baker.
Good morning, Your Honor. Attorney Samantha Sprague, Pete 1931, appearing on behalf of the plaintiff.
Hi, Your Honor. We weren't able to come to
I
an
need
agreement with
names.
Dejan Baker.
All right. Are we on that?
We weren't able to come up with an agreement. I would like to request that this case proceed to trial. I've been dealing with ongoing issues regarding Huron Vista, including attempts to charge me additional amounts that I don't believe are fair. I also want to note that when I moved in, I was not given a properly signed lease. There were more inconsistencies with rent charges, my move-in date and prorated
Ma'am,
rent.
did you pay the rent?
Huh?
Yeah, I don't know what you mean by a properly signed lease.
When I moved in, I did not have a signed lease. I did not sign a lease.
Okay, but you stayed there, right?
Correct.
You paid rent.
Under the impression I had a signed lease.
That's the only reason you paid rent?
No, Your Honor.
In the moment you stayed there and paid rent, you created, the tenancy was created. So I'm not sure why you are bringing up the fact you're saying there wasn't a properly signed lease.
Because I would like to move forward and take this to trial. I don't believe I'm getting my points across.
You don't believe what?
I'm getting all of my points across.
I know, I'm understanding them. But they, quite frankly, I'll be honest with you, I mean, I'll hear the case, had evidence to put on, but I'm not clear what you're really arguing.
What I'm arguing is that I did find the paper that I reached out and submitted in writing about the black mold when I found it in July. I did reach out to the apartment complex. I would like a court reporting attorney. I don't feel.
That doesn't happen in a civil case, ma'am.
Okay.
If you're gonna go to trial, you're gonna have to try it yourself. And my question is, are you prepared to do that? Because you're gonna be bound by all the same rules, the court rules, evidentiary rules that counsel would be bound by.
Yes, Your Honor, I understand.
You're prepared to do that?
Yes, Your Honor.
I don't understand what your defense is to this.
My defense is that since I've lived in this apartment complex, I have not gotten any communication in regards to my problems that I faced living there. I've reached out and talked to more than 5 property managers that's worked there in the past 9 months. All of my problems were not fixed. They were completing work orders that were not actually completed. They were just marking them as complete.
Ma'am, what did they not do?
Anything.
No, that's not an answer.
They did not fix the leak. They did not. I'm sorry.
What do you mean they didn't fix the leak?
Give me 1 second. Landlords are legally required to keep the.
I don't need to be read anything. You have told me that they did not fix the leak. I just went through the whole thing. You agreed they fixed the leak. So what do you mean they didn't fix the leak?
What I mean by they didn't fix the leak, they did not communicate with me as a tenant to give me the communication of when they were going to enter my apartment and how everything was going to get handled. No one communicated back to me in any of the responses when I've reached out to them and let them know the problems that I were facing living there.
Did they fix the leak?
Yes.
So what do you think them, if it's true, which I'm having some doubts that they didn't talk to you at all? What are you claiming that's worth?
I'm claiming that that's worth the $1,790 that they initially brought me to court for.
Because they didn't talk to you?
They didn't communicate and they entered my apartment without permission. They violated my rights. Not only one.
You call, say I have a leak. They at some point, because that's an emergency situation, enter your property. And that's your claim?
They entered my property the same night to fix the leak. And then they tried to enter my property 2 weeks prior to the leak happening to enter my property to fix it with no communication. They came to clean my couch a week after the problem had already happened and my couch was ruined. That's a $2,000 couch that was ruined. The leak was not only in just one part of my apartment, it spread throughout the whole entire apartment. There were cracks in the ceilings that were supposed to be repaired from construction that never showed up.
Entering your unit inconvenient?
It inconvenienced me because I was not only dealing with just
you know
the
what,
leak.
you got your witnesses here today?
I do.
I'm gonna squeeze you in because this is gonna,
I also have
this
a
is gonna
witness.
be a quick trial.
I also have a witness here.
That's fine. I'll hear from everybody. And then I'm more than happy gonna render that. The only issue is that I have criminal cases, those have to take precedence.
Absolutely.
But I'm ready to hear this today. It's not gonna take time at all. I'm gonna tell you right now. Because I do not, I'm gonna let you know, young lady, I will hear anybody's claim. I do not understand your claims. And the claims don't make much sense to me.
And I will make sure that I will make them make sense.
They don't make sense to me. Young lady, I'm trying to communicate something to you. I've been doing the landlord tenant for over 35 years. Your claims don't make sense. But if you want to go ahead and call witnesses, do all the questioning, go through all of that, we'll do it.
Okay.
And then I'll render my decision and you're stuck with it.
Thank you, Your Honor.
Which ones are ready to go? Well, why don't I stand in recess? You get those organized. You guys have something ready to go? I'm not asking, can I? No, I didn't mean that badly. I did. That was so wrong with me. I'm sorry.
Judge, I'm working hard trying to resolve the one thing.
Voluntary and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm not going to go into the matter of the sentence today. We're going to do a level 2 pre-sentence investigation, and we'll see everybody back here in about 6 weeks.
Thank you, sir. Thank you, Your Honor.
Next is the case of Samuel Stacy. This is case number 19 CR 35584. Present before the court is Mr. Stacy, represented by Ms. Hinkle, and we have Mr. Harris in the prosecutor's office. Officer Fisher from probation. We're here today for a final violation hearing. Ms. Hinkle, does your client wish to have a contested hearing in this matter?
No, Your Honor, he will admit to the violation.
Mr. Stacy, do you understand the rights you're giving up by entering an admission to this violation?
Yes, sir.
Is this what you want to do?
Yes.
Do you admit or do you deny that you violated the terms of probation?
I am.
Based upon your admission, I find you have violated the terms of your supervision. Mr. Harris, on behalf of the state.
Your Honor, I was reviewing the report in this case. As you know, this is a 2019 case. The defendant appears to have neglected to come in and do what he was ordered to do, that being 6 years ago, and the underlying charge being a robbery. Just trying to review the facts of this, but it is a serious offense. My understanding is the co-defendants in this case went to prison. I see no other reason why this defendant should not go.
Mr. Fisher?
Nothing further, Your Honor.
Ms. Hinkle?
Thank you, Your Honor. After speaking with my client, the part of the violation was for missing a couple reporting days. My understanding is that my client actually had multiple major massive surgeries on his leg. He was calling probation every month, and when he did find out he did have the warrant, he did turn himself in. He's paid off the restitution in full. He's actually working as a general manager at La Rose's. He's been there for 4 years. He's a single father taking care of his 10-year-old daughter who's actually currently in the hospital about to get a diabetes pump put into her stomach. So I would just ask that you take all of that into consideration and adopt probation's recommendation.
Mr. Stacy, what do you want to tell me?
Basically, she covered most of it. I haven't been in any trouble. I work every day. I take care of my mother, take care of my daughter. When it all happened, I had some major surgeries to where I couldn't even actually stand to come. The probation officer at the time, I don't remember her name because I went through a couple different ones. It was during COVID. She asked me to call once a month, and I did call every single month. And I left a voicemail every single time, and I never got any reply back. And when she finally picked up, she basically just told me I was already violated. Then at that time, my father just passed, so I ended up taking on my mother, and my daughter's mother was really sick, so I ended up taking my daughter too. And I just got a job, and I've just been working ever since. It's literally all I do is work.
When did the restitution get paid?
It looks like I'm looking at another judgment entry, and possibly there was restitution from seized funds that was paid, and this is in the Black case, 800 to Lamont Townsend, joint and several with co-defendants. Restitution has been paid from funds seized from co-defendant Daryl Noel.
All right, so he didn't pay it. Somebody else paid it?
It appears that way. And this is a judgment entry. I don't have a file stamp date on it, but it was back in February.
I mean, I'm looking through the file. I don't see any payments by Mr. Stacy. Right, Mr. Stacy, you didn't pay the $800 in restitution, right?
See, that Daryl Noel is my sister's husband. He might have paid it, but I haven't spoken to him ever since this happened. I haven't been in no contact with him at all.
Well, my recollection of the facts of this matter was, Mr. Stacy, that you were the least involved of these three people. And, you know, my note to myself back in 2019 was that this was a local jail probation case. What I'm going to do is I'm going to sentence you to 75 days in the county jail, credit you the 25 days that you have already done. Technically, you're still on community control while you're in the jail. So if you get in a fight or get caught with drugs, I could still send you to prison for up to 12 months. But serve out your time and be done with us. I can make you eligible for work release, or if you have transportation, I can make you eligible for work release, or if you want to do the litter program. If you do the litter program, you would get an extra day of credit for every day that you do on litter, so you might actually get out sooner if you do litter. Doesn't matter to me.
See, I have a bad leg, so I don't know if would they let me still work?
I mean, I'll give you work release if you can get all of that lined up. Mostly transportation is what stands in the way of people.
Okay.
All right, so go ahead and we'll make them eligible for work release. And then if you decide you can't or won't or don't do work release and want to do litter, just send me a letter. We'll get you on the crew. All right, that's all.
Thank you, Your Honor.
Thank you, Your Honor.
It's Friday court tomorrow. It's still Thursday.
You're on the Friday's Halloween.
People against Kyla Alessia Bynum. 5T721182. All right. Mr. Zayed, your appearance?
The victim's here also.
Okay, perfect. Can I have Mr. Zayed, your appearance, start your video. Ms. Bynum, start your video. And I need the victim, Ms. Moore, to start her video. Good morning, Mr. Zayed, your appearance.
Good morning, Your Honor. Justin Zaid, PA1051 on behalf of Ms. Bynum, who's present, consents to appear via Zoom. Ms. Bynum, can you say your full name?
Kyla Bynum.
Ms. Moore, I need you to start your video, ma'am. You're not driving. Please tell me you're not driving. You have to start your video, ma'am. Unmute and tell me your name.
Peter Moore.
Okay, you're not driving, right?
No, I am. I'm pulling over right now.
Why are you driving when your case?
Huh?
Just pull over, please. I got all these people waiting for me and you. I really
Okay,
not.
I pulled over, sir.
All right, Ms. Bynum, you can get off the phone anytime. I don't know who you're talking to. Are you talking to somebody, ma'am?
Who, me?
No, the person behind you. Yes, you. Are you on the phone?
Yeah, I'm not talking to nobody. No one's in the
What are you
room.
on the phone for? I don't understand. You got the phone up to your ear? Aren't you on Zoom?
Yeah.
Mr. Zayed, I have a stip that says Keita Moore does not wish to proceed. I don't know what he wants me to do on these.
Your Honor, I think that it says voir dire for intention. I think that it indicates, just putting on the record, that it is in fact Ms. Moore's intention not to proceed with this matter. And at that time, I would motion the court for dismissal. I'm happy to just do that now if that's more appropriate.
All right. I just got to ask you a question. Am I missing? How long you been practicing? Can I ask you?
Almost a decade, 10 years.
So I've been a lawyer for 42 next month. I've been here for over 30. For 41 and a half years, the prosecutor's office would move to dismiss this. Say, Judge, we can't proceed. So what I'm going to say to you is this. I don't know why he wants me to dismiss this on my motion once you move to once I'm convinced that the victim does not wish to proceed. Am I missing something?
I think, Judge, every prosecutor's office does it a bit differently. I know that Oakland County will simply defer to the court saying they can't proceed, and then I would move to dismiss. So that's kind of consistent with how they do it in that court.
You know why? It's all political nonsense, right?
Certainly, they don't want to be the one dismissing
I don't like
the case.
politics. I don't like politics.
They don't want to be the one to dismiss the case. I understand.
I don't like politics. I hate politics.
I'm with you on that.
I had to run in 1994, and I just don't understand anymore what's happening.
I understand.
What, to make numbers look better?
Yeah.
I have a good mind to set this for a jury trial and to impanel the jury. And then they're barred from prosecution for all time because jeopardy attaches. That's what I have a good mind to start doing. set them all for jury, panel the jury, and then jeopardy attaches. That's what I have a good mind to do. Did he talk to the victim?
He did.
Did you talk to the prosecutor, Ms. Moore?
Yes, I did.
Do you wish to proceed on this case, or do you wish to have the court dismiss the case?
I wanted to proceed, but I just made the decision after talking to the prosecutor just to drop the charges. I just feel like she haven't learned her lesson.
Wait a minute, look at me. You're looking at the roof of the car. I need to talk to you. I need you to look at me. You said you wanted to proceed, but what?
I don't know. I don't know. I don't know. She just haven't learned her lesson. I just had to have surgery.
Wait a minute. Wait, just talk to me a second here. They're telling me you do not wish to proceed with the prosecution. Is that true or false?
I mean, that I guess it's true. It's true due to the fact, the discussion that we had.
I don't want you to guess. This is too important to guess. You know what I'm saying? I want you to tell me, yes, Judge, I don't want to proceed, or yes, Judge, I do want to proceed. It's up to you.
Okay, I don't want to proceed.
You want me to dismiss the case?
Yes, please.
You don't have any intention of going forward on this case?
No.
You move to dismiss, Mr. Zayed?
Yes, Your Honor, respectfully.
Dismissed, motion of defense.
Thank you very much, Your Honor.
Prosecution. Witness does not wish to go forward. All right, case dismissed. We're going to cancel the bond conditions. Do you have any questions for me, Ms. Bynum?
No, sir.
So case is dismissed, motion of the defense. Thank you very much.
Thank you, Your Honor. Have a good day.
Good day. Good luck to both of you.
Thank you.
Thank you.
Lexi Jane Elaine Don, T5 25B724898. Who's here for, okay, counsel, your appearance?
Did we call Ms. Don's case? I'm sorry.
Yes.
Okay, I'm sorry.
That's all right.
I didn't late. James Drametta on behalf of Lexi Don, Your Honor.
Ms. Don, your name, ma'am?
Lexi Don.
So you're going to try to do what, counsel? Get her into sobriety court or what?
I think that's the plan, Your Honor. I want to talk to Ms. Don about it a little bit, so we'd ask for adjournment so we could get a deviation letter, and I can make sure Ms. Don understands what that involves.
All right, so here's what I'll do. I'm going to set this out, but I want you to understand, I'll give you 2 weeks on the PCC, so that should make it November the 11th. And then the exam.
Judge, that's a holiday. Excuse me, that's a holiday.
Do I have a state day that week?
We were trying to do the 14th, but we haven't received a response from Mr. Mohammed yet.
Go on, Mr. Mohammed.
I think he mentioned that, Your Honor, when I was in a breakout room with him. So I knock on wood. I think that'll work for him.
Good morning, Mr. Mohammed. Your appearance? We tried to reach out, I guess, and see if you could do, the 11th is a holiday, 2 weeks from today.
Yes, on a Friday.
Oh, so you're going to do the 14th for us?
I don't know if it's going to be me, but someone from my office should be covering that day, yes.
Definitely, so I can schedule things up for the 14th at 8:30?
Yeah.
Okay, good enough. All right, so, ma'am, I want you to understand your lawyer's asking for an adjournment. You have the right to a probable cause conference within 14 days of the date of the arraignment. If I grant his request, that means that the probable cause conference will not take place within 14 days. Do you understand that?
I do, Your Honor.
Do you waive that right?
I do.
Anybody force you to do that?
Nobody.
All right, I'll accept the waiver. We're going to set it for November the 14th at 8:30 will be the PCC. preliminary exam will be November the 18th. At what time, Lisa? 10, 10:30?
10:30.
At 10:30. No more adjournments, so council, okay?
Understood. Thank you, Judge.
Good enough. We'll see you guys here then. Have a good day. Anything else? Detective Tulash, your name?
Good morning, Your Honor. Detective Crystal Tulas, Brownstone Police Department.
Anything you need to add or bring up on this case?
No, I hope Miss Dawn gets accepted to the sobriety court program. I think it would benefit her.
Ms. Don, let me see your AA verification. Put it up to the camera.
I didn't hear what you said.
I need to see your AA verification. Put it up to the camera.
Yep, I have that right now.
Have you seen it, Mr. Garametta?
I haven't, Your Honor, no.
I do have it. I have it right here. I have a meeting I'm going to at 9:30. I found a good spot to go to.
You've been at least 6 times so far?
I have. Yes, I have, Your Honor.
Let me
get
see it,
back
please.
Here, one moment. Let me figure out how to turn the camera around.
Are you on a scram tether?
I am.
Okay. Okay, good enough. We'll see everybody here on November the 14th at 8:30. Thank you.
Thank you.
Thank you, Your Honor.
Thanks. Joshua Michael Skeens. This is file number 24M715739.
Good morning, Judge, staff. John Graziani, P number 433.
Can I have a probation?
We have Joshua Skeens. Judge, as you can tell, the letter has been submitted.
Let me ask Mr. Skeens his name first.
Go ahead. It's Joshua Michael Skeens.
All right. I need a probation order, please. All right, we do have this letter from the Monroe County Treatment Court, Circuit Court treatment. The court is probation department's recommended jail. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
Judge, I did very little on that. We were just simply submitting. We were just concerned about the submission of the letter. We felt that he could continue on with the program. We're just asking for mercy again because the fact that he's been working, he has complied with that, with the exception of what happened in this jurisdiction, Judge.
Can you do me a favor and call in Beth? Give me 1 second, please.
Again, he showed up over here. He's been pretty good in compliance and he was working.
Who owns the car he was driving at the time of this?
I was the owner of the vehicle.
So I want you to understand something. I'm going to be you had a drunk driving conviction in 24. You understand that, right? I need to wait for the probation officer.
You want us to just take?
No, you're fine. She should be in momentarily. I just want to. Get a hold of her, John.
I had you hold hand, that wasn't actually the phone.
Is Ms. Wilds here today?
She is, but I was the one that contacted the Monroe, so I can work for you.
So she sent you in?
Yes. I attached the letter that they.
I know, I want to make sure I'm doing this right. If I wanted you, I would have called you. I need her.
Okay. Sobriety court related.
Correct. To ever come in.
Yep.
Ms. Wild's your name? I
Commissioner.
haven't done this in a while. I'm gonna make sure I'm doing it right. So she's gonna be in the treatment court there in Monroe. As I recall it, all I'm doing is assessing fines and costs, and I'm gonna order him to successfully complete that program and provide proof.
Yes, Your Honor. Are you?
I'm gonna keep him, nope,
No.
I'm gonna keep it here. But,
Sir, you gotta take your hat off.
I'm gonna keep it here, and I'm just gonna order him to comply with all terms and conditions of their treatment court, fine him. And I don't think I'm gonna order anything else. But 93 days if he doesn't comply.
Yes, Your Honor. And that's perfect. If we're not transferring that.
This fines, cost, probation fees, true?
Yes, sure.
All right, you're all set. Thank you. 24 months. Did I let everybody finish over here?
Judge, I'm set except the state because of the fact that he's currently got that Monroe County scenario with the sobriety court. I'm asking that there be nominal fines and court costs. Because this gentleman's making about $15, $16 an hour. I make $15, $17.
All right, anything else?
There's nothing else, Judge.
Is there anything else?
On my behalf, I would just like to say, this did occur here in jurisdiction, and I apologize for.
Listen, this is your last chance. If you weren't in their drug court, you'd be going for 93 days, right?
Yeah.
So you've used every available break that one's entitled to in this world.
I understand.
I mean, I'm not that. I'm gonna trust that you're being really compliant and that your heart's in it, because I gotta tell you, if you don't turn your life around at this point, I don't think it's coming.
And that's understandable.
24 months probation, you cannot leave the state without the consent of the court to violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. Your motor vehicle, I don't know if they ordered this, but I have to order that it be immobilized within 7 days. We have to order a mobilization within 7 days for a period of, I'll give you the minimum for 90 days, okay?
The vehicle, excuse me, has been sold.
Then I'm gonna need proof of that. You're gonna have to go to the Secretary of State, and you're gonna have to provide me with proof that that vehicle's titled in somebody else who's not a relative's name. Do you understand that?
Yes.
My order is that you comply with all terms and conditions of probation in the Monroe County Treatment Court. I'll go light on your fines, 100 fines, 300 costs, 75 victims' rights fee, $50 justice assessment. So fines and costs are 5 1/4, screening fees 60 for 585, probation fees are 480 for a total of 1,065. If you violate, your probation could be revoked, you could be incarcerated for 93 days. So again, I'm running these terms concurrent with Monroe Treatment Court. So if you violate there, you violate here. Do you understand that?
Yes, sir.
I'm telling you, you got to change your life around, son, or this record is horrific. I will let you pay this at the rate of $50 a month. I will start this beginning November the 10th, and the 10th of every month thereafter. If you don't have the money at any point, you come in here and talk to me or call the court. We'll go on Zoom on or before the due dates. Be glad to give you an extension. I don't care how many times we have to do it. You'll meet with probation. You're all set. I really wish you well. You gotta embrace that program. I'm telling you, your record is, you're gonna end up in prison, not jail.
Yes, sir.
Good luck. Thank you.
Thank you, Judge.
People against Nate and Sarah Consulting. Nate and Sarah Consulting. This is file number 25SO22343A and B. Your name? What is your position? I mean, you got a misdemeanor here. I can't really let you represent the corporation. Didn't we talk about this before or not? Okay.
I actually had an attorney, but he wasn't able to represent me in this case.
Who? Because he's my brother, you mean?
Yes.
I'd be harder on you if he was in. I'm just kidding you. Let me, you still need to hire a lawyer, okay? All right, so let's, I'll give you a 2-week adjournment. It'd be fun to have him in here. I could really mess with him. We'll adjourn it for 2 weeks or 3 weeks, Lisa. 11/18, but you do need a lawyer, okay? I can't let you represent the company on a misdemeanor. This is a corporation, correct? Yeah. November 18th, okay? All right. Have a good day. Thank you. People against Nelson, Michael DeWan, Timothy Nelson, 25I-713-782. Mr. Pietnik, good morning. Your appearance. Mr. Pietnik? I think he's on Zoom. There you are. How are you? Your appearance, Mr. Pietnik?
Good morning, Your Honor. Michael Pietnik here on behalf of Mr. Nelson.
Where is Mr. Nelson, Lisa? Is he out there?
Not on Zoom.
Was your client out there today, Mr. Pietnik?
No, he was going to appear by Zoom. I'll call him right now and have him. We talked yesterday. I sent him the Zoom ID, so I'll call him right now and have him hop on.
Yeah, please do. Thank you.
Thank you, Your
William
Honor.
Frank Weisenstein, file number 25W7232554SM.
Morning, Dr. Dan Welcher on behalf of Mr. Reisenstein. Sir, state your name.
William Frank Weisenstein.
All right, so what are we doing here? This is a plea.
That is correct, Your Honor. We're asking for a no contest plea due to civil liability. There's conflict of interest between these two parties. There's a recommendation from the prosecuting attorney for 12 months of probation and a remanded commitment, which is, of course, a recommendation.
Okay. Is that what you want to do, sir?
Yes.
And you stipulate I can use the police report to establish a factual basis?
Yes, sir.
Can you mark that? Sir, if you plead no contest, Tabitha, I need you to mark this, please. If you plead no contest under 7694A, I'm sorry. If you plead no contest under 7694A, it has the same effect as a guilty plea. Here are the possible penalties: up to 500 fines, 93 days jail, costs are all those. You understand me?
Yes.
I'll defer the proceeding. I'll order a pre-sentence or screening and assessment. You'll come back. I'll set terms and conditions of probation. If you're compliant at the end of the period that I set, the case would be dismissed. You understand me?
Yes.
You agree to that?
Yes, sir.
All right. And did you sign, read, and understand an advice of rights form here today?
I'm sorry.
Did you sign, read, and understand your advice and rights?
Yes, I did.
Okay, if you plead no contest, you will be giving up all those rights and there will not be a trial. Do you understand that?
Yes.
Okay. Any questions before I go on?
No,
For the charge domestic violence, how do you wish to plead?
no contest.
All right, I'm going to review the report. I've had it marked as Peoples 1. Is there any indication in here anywhere that there was alcohol or drugs involved?
No.
Has anybody forced you to plead no contest?
No, sir.
Good enough. I'm going to go ahead and accept the plea. I'll defer it under 7694A. I'm going to order a pre-sentence report. We'll give you a sentence date. So you're going to go over down the hall when I give you a new sentencing date, then you're going to go over to probation, you'll be interviewed, and then you'll come back for sentencing. What do you have for me, Lisa? Are we going to go to the 3 weeks out?
Yeah, November 18th at 8:30.
I have a conflict that day.
Okay.
be in another jurisdiction. Is it possible to have the 14th?
Can we do the 14th? Any reason we can't do the 14th?
No, we can do that.
Let's do the
8:30.
14th at 8:30. You gonna be able to get out of bed, Ms. Belcher?
And on time.
I know you are. That's why I asked the question. That's why I asked you the question. All right, give me 1 second. What is this? I just need to check one thing here. Yeah, Judge Hester had already signed the warrant back on September 26th. So you understand everything, sir?
Yes, sir.
Do you have any questions?
No, sir.
Anything else?
Not for the defense.
All right, have a good day. Thank you very much. Thank you. Do we have Mr. Nelson out there yet? People against Ronnie J. Goshen. 25D12595. Come on up here, sir. How you doing?
Pretty good.
What's your name?
Ron Motion.
You been to court a lot?
Pardon me?
Have you been to court much?
No.
Good. All right, so this is a handicap parking and you have the sticker. You just have to make sure that's on your mirror, okay? Nice and visible, all right? Okay, so they're dismissing, case dismissed. Congratulations. I wish you well.
Yeah.
Good luck. Lyric, Alicia, Estrada, Martinson, 25S569589. I'll be right with you, Mr. Cripps. I don't know what case you're here on. I'll get it. Is Sergeant Cadez here?
No.
They're coming in.
Yes.
It's just a little slow today, moving slow.
That's okay. All right. Sergeant, your name, please, Sergeant Cadez?
Sergeant Rick Cadez of the Wayne County Sheriff's Department.
Good morning to you. Lyric, Alicia, Estrada, Martinson is not out there, right, Lisa? There's a sticker here that says no. Do you see her out there, Lisa?
No, she's not on Zoom.
She's not in the courtroom. Case was scheduled for 9. I gave her 15 minutes. It's 9:25. Default judgment entered in favor of the plaintiff and against the defendant. Mr. Cripps, what case do you have, sir?
Sergeant Cadez has one more.
Good morning, Judge. I have Mr. Matthew Levens. He should be in the courtroom.
I have it. Can you see if you can dig that one out? This is Jerry Lewis Burns, 25S571267. Sergeant, your name again?
Sergeant Rick Cadez of the Wayne County Sheriff's Department.
Morning, Mr. Burns. Your name, please, sir?
Jerry Lewis Barnes.
How you doing, Mr. Burns?
I'm doing okay. How you doing?
Good. He's charged with 20 and a 15. He's got a clean record. You offering impeding?
Yes, sir.
You want to plead to impeding traffic, Mr. Burns? That's 0 points. It won't go on your record. I'm going to fine you.
Yes, Your Honor.
To the charge impeding traffic, responsible or not responsible?
Responsible.
I'll accept your plea. Dismiss the speed, 150. Can you pay that today?
Yes, Your Honor.
Okay, you can just go right online, 33court.com with your case number and you're all set, okay?
Okay, thank you, Your Honor.
Thank you. Is your client out there yet, Mr. Pieknik?
Yes, he is, Judge. My apologies. When I sent him the Zoom number, I flipped the last two numbers as 1-3 instead of 3-1.
Michael DeJuan Timothy Nelson, 25I713782.
Good morning, Your Honor. Michael Pieknik here on behalf of Mr. Nelson, who appears via Zoom as well.
Good morning, Mr. Nelson. Your name, sir?
Michael DeJuan Timothy Nelson. Good morning.
Good morning to you. So we have one, I just want to double check here. One count of identity theft. I understand this is going to be a waiver, right?
That is correct, Your Honor.
Sir, you have one count of identity theft. It's a 5-year felony. You have the right to a preliminary examination on that charge. If you waive your right to an exam, and that's what your lawyer is telling me by this stipulation, then you're going to waive the requirement that they prove that the crime was committed and that you were the one who probably committed the crime. You'll automatically be bound over for further proceedings to the Wayne County Circuit Court. Do you understand that?
Yes, sir.
Is that what you wish to do?
Yes, sir.
Anybody force you to do that?
No, sir.
Waiver's accepted. He's posted his bond. I'm accepting the waiver. Bond's at 5,000, 10%, and it's posted. Prosecutor does not indicate they have any objection to the bond being continued. He says no objection, a waiver on the stip, but not to that. When do I set this, Lisa? Is it going to the 12th, or how are we doing this?
I honestly don't know. They didn't send us an update.
I'm going to set it for the 12th. If they get mad at me, well, they can get mad at me. I'm going to set it for the 12th.
Okay.
And that will be at 9 o'clock in the morning, okay? Anything
Your Honor.
else, Mr. Pieknik?
No, Your Honor, not today.
Mr. Nelson, do you have any questions for me at all?
No, sir.
All right, best of luck to you, sir. Bonds
You
continue.
too.
People against Matthew James Levens, 25W702931. Good morning, Mr. Cripps.
Good morning, Judge. David Cripps, P34972, appearing on behalf of Matthew Levens, who should be in the courtroom. And Judge, the specially assigned prosecutor, Brittany Johnson, is in the waiting room.
Okay. Bring Miss Johnson out if you would. Good morning, sir. Your name?
Matthew Levens.
All right. Let's bring out Ms. Johnson. One thing, your client, I don't believe has been printed yet. At least there's a note on the file. Well, wait a minute. He must have been printed. Did you go get prints?
Yes.
You sure?
Yes.
Yeah, it just got the arraignment date on here. So he did get printed, I think, Lisa. If you disagree with me, let me know. Ms. Johnson, what are you guys going to do? Are you going to pick out a date for me and we'll...
Judge, I'm sorry.
She was in the waiting room and she's no longer here.
Okay.
Judge, I spoke to Ms. Johnson. I'm making a request for referral for competency to stand trial. I've had attempted conversation with my client. I believe that there's some questions about his competency at this point in time in terms of ability to rationally assist me.
I got it. So she did not seem to have did she have any objection?
None whatsoever.
She's back, Judge. Here she is.
Ms. Johnson, come on in if you would, please. Morning, Ms. Johnson.
Good morning, Judge.
How are you? Can you start?
Good,
the
how are
video?
you? There we go.
She might be the most pleasant prosecutor in the county, Mr. Cripps. You know that? She's always got a...
I don't disagree with you.
I mean, it's great to see. Even when I'm having a bad day, you see her smile, and it's like, geez, this is great. Okay.
Thank you, Judge.
So he's telling me, I mean that as a compliment, not to embarrass.
No, I
He's telling
appreciate
his
it.
client, he tells me that his client, he thinks needs a competency exam. Any objection?
None, Judge.
What do you guys want to do? I'll send the order out today, but I think I'll put this out for don't forget to get this when you get back and do the seals, okay? I'll put this out for like 9 weeks or so. Is that about the time you guys figure it's taking?
Yeah.
That sounds right.
Okay, Lisa, give me a date, would you please, for review? So, sir, we're going to send you an order for competency, and we're going to send it to the forensic unit, and they're going to give you a time, and you got to make sure you show up for that. Do you understand what I'm telling you?
Yes, Your Honor.
Okay. So when do you want to give me, Lisa?
December 30th at 8:30.
Yeah, you're acting like I'm going to be here December 30th. Can we go into January?
That'll go to Judge Hesson then January 6th at
I don't think
9.
you guys, please tell me how long they're taking now. I haven't been, I've been on the state docket for a while.
2 months. 2 months for competency.
2 months.
Well, then let's do it. Shoot. Do we have a week before that we can see, like December 23rd? Are we open December 23rd?
Yes.
Let's do it on the 23rd. And we'll do that at 8:30, okay? And if we don't have the report, I'll just adjourn it into January. All right?
Thank
Sounds
you, Judge.
perfect.
You're going to go down the hall, get your notice. We're going to send out an order for competency and we'll see you back here on December 23. Make sure you show up. Anything else, Ms. Johnson?
Nothing, Judge. Thank you
Anything
very
else,
much.
Mr. Cripps?
No, Judge, but I'm gonna start working on my smile so I can match up to Miss Johnson.
Your smile.
And there are a few items that are making some progress. So,
All right. Did you guys need my help or
Not
not?
on this one, Your Honor.
I think
I don't know what that means.
I, on the contrary, always think you're helpful. So,
Wow, he just, how'd that bust?
Boy.
How'd that bust feel? Probably see the tire tracks now.
yeah. Okay, I don't know. Counsel.
Are you guys far apart or, I mean, where are you? I'm just trying to.
There are some financial issues which are inhibiting resolution, but there are also some just practical ones, some pragmatic ones that make things difficult.
I agree, Your Honor.
And knowing how much Lacey is, she doesn't care about the practical.
Oh,
Oh, wow. I know that was awful to say, wasn't it?
Yeah.
Judge.
Started throwing that out there. All right. So when do you guys want to try it? How soon?
Does the court have room before the end of November?
I'm not going to be able to try it that quickly anyway, Judge. And quite honestly, with the discussions we need to have, any meeting or time than that. But I have got trial scheduled for December 1st on respectfully a case that's going to be taking a large portion of my time. The other thing I will tell the court that I have can we approach real quick? Yes.
That'd be in person. All right.
Thank you.
Thank you, folks.
Thank you.
Thank you, Judge.
Thank you.
Thank you.
Mr. Hampton, all the best to you, sir.
Thank you. Thank you, Judge.
Court does call the case of Strong Future Homes versus Webster.
Good morning, Your Honor. Carissa Gazari appearing for plaintiff.
Hello.
Hello, Judge. How are you?
I think I'm okay. Never know till the end of the day. Your name?
Veronica Webster.
I have before me and have reviewed a conditional order dismissal. Is that what we're looking at here?
Yes.
Yes.
All right. Ma'am, do you have any questions regarding this conditional order dismissal?
No, I discussed everything with them and I appreciate them willing to give me a chance. It's just some things I have to do and follow to stay. And I plan to do it.
Okay, so you think you comply with everything that's in here?
Yes.
Okay. I've looked it over and it does appear fair and equitable to me in regard to this. So what I will do, you have no other questions regarding this?
No.
No.
No, sir.
I will sign off on the conditional order dismissal. I do have to advise you, ma'am, you have been advised that you have 3 business days to think about this. If you think that there's some legal reason, some confusion on your part, or some right you didn't assert, you got to file a motion with the court within that time frame to set this aside.
Okay.
Huh? Doesn't mean I would grant it, but you'd have that time.
Okay.
Okay?
Yeah.
All right.
Thank you.
Thank you guys for working it out.
All right.
Thank
You
you,
have
Your
a great
Honor.
day, Your
Have a good
Honor.
day.
I'm gonna try. I'm gonna have a good day. Is everybody else that have problems, right? Thank you, Ms. Webster.
Good.
Court calls case, People versus Michael T.
Good morning, Your Honor. Rachel, Assistant Prosecuting Attorney on behalf of the people.
And good morning, Your Honor. Christina Costantino, appearing with and on behalf of Mr. T. Mr. T, can you state your name for the record?
Michael T. Thank you. He's waving.
Yes, Your Honor. And there's, yes.
Your Honor.
Can I stop you? No, go ahead.
I will stop here.
No, you wouldn't. Go ahead.
Your Honor, as I indicated to the defense counsel this morning, while we are missing an important witness, this is a case where we would ask the court to be able to proceed under 768.27C as well as people only on most accounts. So Your Honor, if I may go through count 1, we would be able to proceed in such manner if the court allowed. Count 2 as well. Count 3, we would not be able to proceed today. So I'm sure counsel is going to ask for dismissal of that count. Count 4 and 5 are misdemeanors, so we would ask that those follow counts 1 and 2. Your Honor, that would have been our intent today, is to proceed under that authority. And my understanding is that the defendant's going to waive on those counts.
So just so that I'm clear, he's waiving on 1 and 2, 3 is being dismissed, and 4 and 5 are following.
I thought 1 was being dismissed.
I'm sorry?
I thought 1 was being dismissed.
I'm sorry. Yes, Your Honor. Thank you. Count 1, Your Honor, even though we would be able to proceed if the court allowed under People versus Old Main statute cited, we would agree to dismiss.
All right. So you're going to waive, he's waiving on count 2 with 4 and 5 following, right? Okay.
Yes, Judge, that would be correct. And if I could, I do.
Yes, go ahead.
So my client and I, Mr. Teague and I have discussed this. It's my understanding that he does understand that the people could proceed under the court rule on the assault with intent to do great bodily harm charge, the felonious assault, and the count 2 felonious assault. And that after full discussions that he is intending to waive his right to an exam. In exchange, the people would dismiss count 1, assault with intent to do great bodily harm. So the waiver would be with regards to count 2, felonious assault. We, the defense, would be moving for dismissal of count 3, felonious assault, as the people are unable to proceed on that charge. The 2 misdemeanors, of course, I've explained to him he does not have a right to have an exam in those matters, so those matters would follow. Is that correct, Mr. Teague?
Yes. Yes. All right. You had an opportunity to have a full and fair discussion with your attorney regarding it. All right. Sir, along those terms, you're willing to waive your right to have a preliminary examination? Yes. Yes. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them? Yes, sir. You understand you'll not have that hearing and that you'll proceed to circuit court on counts 2 and the misdemeanors following? Yes, sir. You understand that, sir? Yes, sir. People also waive their right. Yeah. All right. Preliminary examination having been waived, defendant is bound over to circuit court on count 2 with 4 and 5 following.
Your Honor, with regards to the information, we would stand mute and waive a formal reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to counts 2, 4, and 5. Counts 1 and 3 being dismissed. Pretrial in this matter will be set for
December 18th at 1:30 with Judge Slay.
December 18th, 2025, 1:30 before Judge Slay.
Your Honor, if I may address one other thing.
Yes.
Your Honor, I want to make sure that at this point, it would essentially just be a warning or request from the court to defendant to make sure there's no contact with the victim. We also want to make sure that he understands that applies to other third parties.
All right.
And Your Honor, my client and I have discussed that today. He is aware, of course, of the no contact order. We've discussed. Sorry, got distracted by Officer Allen. Judge, we have discussed.
Feeling.
Yeah, it happens. We've discussed the no contact order. He understands that he cannot have contact not only with the complainant, but third parties, intending that contact to get back to or involve the complainant. So we have discussed that. It's my understanding he is aware of that. Is that correct, Mr. Teague?
Yes, ma'am. All right. So, sir, you understand all of those terms in terms of the no contact. It's no contact is no contact. That's it. No contact. And that means even through third parties. I will give you this ammunition. I'm sure she wouldn't care. You don't want that issue if it arises coming before me. I will tell you that Judge Slade does not tolerate that at all. So I'd suggest that you follow the advice of your counsel and make sure none of that occurs. Understood?
Yes, sir.
All right. Bond will continue.
Thank you very much, Judge. Have a good rest of your day.
It'll never end. Do you hear? Okay, let's do it. Where's Mr. Brown? Okay. Yeah, Ms. Constantine, you may want to move out of the way there.
Oh, sorry.
So, no, you can stay there if you want. Did you have the paperwork? Oh, you're bringing it. Okay. What's my date? 28. Court does call the case, People versus Joshua Wara.
Trevor Mabel for the people here.
We are ready in this matter. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Wara. Mr. Wara, state your name for the record.
Joshua Wara.
All right. And this is a date and time I had set preliminary examination in this matter. My understanding is you would like a forensic evaluation.
That is correct, Your Honor. Based on my conversations with Mr. Wara.
Forensic evaluation for what? What's going on here?
Based on my conversations with Mr. Wara, I believe that it is necessary.
Hey, I'm representing myself. What are my charges? What am I in here for? I'm representing myself. I don't need a barcode to represent myself. What am I in here for? What charges am I on here for? I don't need a forensic exam. I'm not mentally disabled. I have ADHD and PTSD. I'm perfectly fine. I'm not on Social Security.
Sir, you are before the court on a felony complaint that alleges that on or about, as I read to you before, October 15, 2025, location of South Main Street and East William Street in the city of Ann Arbor, Washington County, state of Michigan, that you did fail to stop at the scene of an accident resulting in serious impairment or death. Individual.
The guy was
That is a
perfectly
felony.
fine.
That is a felony, punishable by up to 5 years incarceration and a $5,000 fine plus court costs. You do understand that, sir?
I understand that. Thank you,
All right,
Mr.
count
Simpson.
2 on that complaint alleges that on that same date and at that same location that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yeah, I understand that.
All right. So that is what you are here for.
Mr. Simpson, I'd like to subpoena the camera footage from the mobile gas station there on North Main Street that I was at, or on South Main Street where I was at, over on South Main Street in Maynard. My car was parked there the whole time. I accidentally hit the guy. They hacked the light using an AI.
Sir, Mr. Warren, I'm going to suggest to you this. Refrain from saying anything because anything you say can be used.
Oh, I know. They used an AI ethical hacking app, the Tomboys and the Ku Klux Klan, and they had broken my glasses when I wasn't. They took my car for a joyride and broke my glasses while I was at St. Joe's Hospital.
The Klan did?
Huh? Yeah, the Ku Klux Klan. You can subpoena video records, and I subpoena the security guards from St. Joe's Hospital, Trinity Hospital.
That's one of the reasons, sir. That's one of the reasons why you have an attorney. Did you let them know that?
No, I don't have an attorney. I told them I don't want anybody to represent. I said I'm representing myself. Yes.
Is that what you want to do?
Yes, I would like to do that.
Sure.
And I would like to subpoena the camera footage from the mobile gas station.
Now
on
knowing
Maynard,
what the
South
charges
Maynard.
are, sir, that if you elect to represent yourself, you'll be held to the same standards as an attorney would regarding the rules of evidence and procedure in the courtroom.
Yes, Your Honor, I
And
understand
would
that.
not be shown any favoritism.
Yes, and I would like to subpoena my discovery packet, please.
If at some point in time you wish then to be represented by counsel, you need to make that request to the court.
Okay, I've
to
tried calling
do
the
that.
public defender's office and I've tried to tell them I want to represent myself. And I've tried to subpoena my discovery packet and they won't bring it to me. I need to subpoena my discovery packet for all cases available, please. And I would like, yep, and I would like to also subpoena everybody's address in the MDOC that's involved in the Neuralink case through Secretary of State, phone numbers, text messages, and visual voicemail records. And I would like to subpoena the phone recordings, Securus GTL recordings from when I was in the MDOC at ARF level 4 and WCC pictures and.
Sir, I've listened to you both through the last hearing and this hearing. So what I'm going to do at this point is I'm not going to relieve the public defenders, but I am concerned, while you have indicated to me that you don't need a forensic evaluation, the court, in listening to you, does believe that you would need a forensic evaluation.
No, I'm perfectly fine, Mr. Simpson.
Sir, for your own
I'm not on Social
protection and
Security.
preservation of your rights.
I'm not on Social Security. I'm over the age of 25. I'm not mentally disabled. I do not need a forensic.
And sir, here's the thing.
I do not go to the
to-
forensic center.
I have to, in terms of these proceedings, make sure that you are competent and.
Oh, I'm very
no
competent,
link.
Cedric Simpson. You can tell. I'm very
Thank you, sir.
intelligent. I have a
And
GED.
that
I got a
you've got
GED in
GED.
2013 in 3 months.
All right.
I got a GED from Washington Community College Adult Transitions Program in less than 90 days in 2013. You can subpoena that record. If someone can get a GED in less than 5 months, I'm pretty sure they're competent. And I would like to subpoena my GED from the Adult
Then you
Transitions
can
Program
do
in
that.
2013
You
at
can-
Washington
you
Community
can draft a
College.
Subpoena. I will not relieve the public defender at this point, but I will consider certainly that once the.
Thank you. Yeah, that way,
Forensic
if you see I got a GED from WCC
I
in
am-
2013 in 3 months, you know I'm competent. You know what I'm saying? Thank you, Judge.
I am going to order a forensic evaluation. I will set a competency hearing just to make sure. I'm going to set that for January 29th, 2025.
January 29.
AM. I will sign an order to.
Can you give me a
the effect
PR
at
bond,
this
please,
time.
Judge?
I'm sorry.
Can I please, I would like to request a PR bond.
This time you can file a motion or somebody can file a motion before the court and I'll consider a written motion, but at this time I'm not going to change the bond in this case.
What is the bond?
Currently, your bond is set at $25,000 cash sure.
Do you have any bail bondsman numbers for me that I could get a hold of, please?
Sorry,
I'd like to subpoena a bail bondsman phone
Check
number.
with the individuals at the jail. I'm sure they'll be more than happy to assist you in that regard. All right, so that you understand, I'm leaving the public defender on the case at this point.
No, I don't want a
Get
public
the
defender.
evaluation. I hear you, but I'm telling you what I'm doing. We will get the evaluation. I'd suggest that you be cooperative in that. You may be right, it'll come back competent, and then we can get this proceeding moving even quicker.
Not gonna come back, huh? Y'all gonna try to.
Before we go off the record.
Y'all corrupt it. Y'all fucked up, people. Y'all people fucked up. Y'all.
Okay, keep moving. All right, been a pleasure.
I'm Benjamin Franklin's son.
Me too.
I just want to.
Because Paris is lovely in this one.
I just want to address one thing, Your Honor, relating to the prosecutor's office's responsibility of providing discovery and as we move forward in this case. The defendant, in attempting to represent himself at the PCC on Thursday last week, stated that he didn't need an attorney, he didn't want an attorney, and that he didn't need the discovery either, that he knew what was going on and that he wasn't worried about having all the video prior to today's hearing, and we were prepared to proceed today. At the same time, under normal circumstances, we would be in the process of getting all of that video discovery to defense counsel that he referenced wanting today. He mentioned wanting the video at the intersection. My office is in the process of getting that hopefully before the weekend. And I'm looking for permission to provide discovery to Mr. Brown's office on this file moving forward.
In response, Your Honor, as we are still on the case, I would ask that they provide discovery as they normally would.
And then if in January, depending on what happens, then certainly that information can be tendered either if he's going to represent himself, which he may be entitled to do, then the public defender can turn it over to the prosecutor, as we have in other cases, can supply it directly to him.
Understood.
All right. Thank you. At least I wasn't called the Illuminati in this one. Well, that's also called a bunch. It was also called a bunch of other things, but that's okay. I'm good with that. I'm confident in me, so I. Is that your only case, Mr. Brown?
I think. It's so long.
Court calls the case of the People versus Brandon Nash.
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. Nash. This was Mr. Mayville. Was just here. Should I go step outside and try to locate?
No, you stay right there, Mr. Jerkus.
Just coming back.
Mayville for the people, Your Honor.
All right, I have before me a plea form that indicates the defendant is going to be pleading no contest to the charge of retail fraud in the second degree. The 1-year offense upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's completely accurate.
That's correct, Your Honor. And I don't know if Mr. Nash, did you say your name for the record?
Brandon Nash.
Thank
Your
you.
Honor. You're welcome.
May I have it?
Raise your right hand. Do you solemnly swear the affirmative testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Brandon Nash.
Sir, it is this court's understanding that you're going to be pleading no contest to the charge of retail fraud in the second degree. That's a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. Do you understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Still wish to plead no contest?
Yes, Your Honor.
Basis for the no contest plea?
Potential civil liability, Your Honor.
And sir, to the charge of retail fraud second degree, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as other rights contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor.
All right. Were you on probation at the time of this offense?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
Court has been provided Pittsfield Township Department of Public Safety report for their case number 254132. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, the court would no longer be bound by any sentence evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
Not specifically, Your Honor, but I do believe that the defendant was on parole at the time of this offense.
Sir, is that correct?
Yes.
All right.
Yes, Your Honor.
So I asked you whether or not you were on probation or parole. So you were on parole.
Yes. Yeah.
I then do have to advise you that your entry of a plea in this case could be a violation of that parole. You understand that?
Yes, Your Honor.
You understand that as such, you could be sent back to do the tail or the remainder of your prison term. You understand that?
Yes, Your Honor.
And understanding that, do you still wish the court to consider accepting your no contest plea in this case?
Yes, Your Honor.
All right. And Mr. Bernstein, are you aware of any other promises, threats, or?
No, Your Honor.
Incorrect, Your Honor. I'm not aware of anything else.
All right. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, sir.
Yes to both, Your Honor.
All right. Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be.
December 10th at 9 a.m.
Just say it again.
December 10th at 9 a.m.
Nothing between those 2 dates then.
No.
December 10th, 2025. You said 9 a.m.
Yes.
9 a.m. That is before me. Bond in this case will continue. Thank you.
Your Honor, thank you, Your Honor.
Thank you. You can stop down at my probation department to start the process with them. They're on your left as you go down the hallway.
Okay, thank
Right?
you.
Thank you.
Well,
Ms. Baker? You had indicated, and I just wanted to advise you that you had wished not to have a judgment in the case.
Correct.
Okay, I want you to understand that if I hold your trial and I render a decision, you will have a judgment if it's against you. You understand that?
Yes.
You understand also that if you wanted to speak with counsel, there are ways of working it out where there would not be a judgment on your record.
Yes.
Have you talked to counsel about that?
I have not been able to get in contact with anyone from council.
No. The individual here today.
Yes. Sorry.
Did you talk to her about that
Yes.
scenario?
Yes.
Did you guys talk about that scenario?
Conditional dismissal with a payment.
But you're not interested in that.
No.
I'm just saying, because you had indicated to me that you did not want a judgment. And you understand that if I render a decision, it's not going to be with the payment plan if it's against you.
I have a question. That being in mind, would I have time? Would I have time to think? If it was rendered?
Ma'am, the best I can advise you, because I want you to fully think about it, is that you might have time to pay, but any remedies for collection of that, including like garnishment, other things.
I still want to proceed.
So you're going to interrupt me again?
Sorry.
I was answering your question, but it seems you want to just proceed it. You can do what you want to do. I know. Let me do a couple of things. Okay, go ahead. I gotta figure out this one. When is that set for? No, the other one.
Oh, next week.
Court does call the case of Anderson versus Lyman. State your names.
Lori Anderson.
All right. We're here today for a decision on this case, but I'm a bit confused about one thing. Ms. Anderson, you filed a new case for non-payment?
Yes, that was just to make sure for,
Make sure of what?
she hasn't paid September, October, or rent, so. I was told to file a 7-day.
Did you put September in escrow?
No, I have not.
When are you gonna do that?
This Friday.
This Friday? And then what about October?
I'm gonna get that in as soon as possible as well. I don't have a deal.
So
I thought I was supposed to,
what?
sorry.
What did you say?
I thought I was supposed to, since she was late for rent for 3 months.
Well, if I render a decision on this case, something's got to be done with that one because this is a non-payment also.
Yeah, it is, sir. I'm sorry.
When is that set for?
November 7th.
That's the 8:30 hearing.
Yes.
My date after that is in what?
It's
No, no, this for Tuesday. So here's what I'm gonna do. That case, have you been served on that case, ma'am? A new one
So, yes.
to come to court on the 7th?
Yes.
All right. I don't know why that was done, but it's now caused a bit of confusion procedure. Yes.
I thought I was supposed to when it was late. I'm sorry if I made a mistake, but
Well, there's an escrow order that's in this case. I mean, and you went through a whole hearing on this case.
yeah.
And I'm gonna render a decision, but that other case is outstanding. So what I'm gonna do is I'm gonna let that proceed on the 7th. I'm gonna adjourn this case to, my decision on this case to November 18th to allow that case to catch up because I don't want a stray case out there. You have the option if you want to, I'm still adjourning this one out to that date, but you do have the option that what you can do is you can dismiss that other case because I don't know what you would get out of that case that you wouldn't get in this case.
Can I dismiss the?
I don't have it in front of me. I don't even know why you filed it.
Can I dismiss this case and just go with this one on the 7th? Since it's for non-payment of rent? That's what I prefer to do.
I'm not gonna relitigate this whole case.
I just
That's
want,
what you want to do.
no, I just want to do it for non-payment of rent. I can dismiss the first case and just,
Well, she's got some counterclaims. You want to just dismiss this case and just go forth on the
Might as well keep going. We've been here since June, so.
Oh, I know.
I mean, there's also an outstanding water balance of almost $1,500. So I would just rather cancel this case since I'm the plaintiff and then just go with the 7th.
Yeah.
The water bill she mentioned, she took the water bill out my name and paid it in full.
It was due on the 6th and they said it would go on my tax bills if I didn't pay it.
I don't know why I'm talking about a water bill at this point.
Sir,
What do you want to do? Because you've got this thing all over the place.
I'm going to withdraw this case and just go with the 7th for non-payment of rent. She's 3 months behind right now. And the water bills.
How can she be 3 months behind? She's
September, October, and then it'll be November, and then the water bill of $1,500. So it's well over, she owes a total of $15,000, a little over 15, and she has 6,600 in escrow. So it's getting deeper and deeper. The further we delay it, the bigger the hole gets.
I'm not delaying anything. You keep doing stuff.
I want to withdraw this one and just go for the 7th since I'm the plaintiff on both. For non-payment of rent, that's all I'm concerned.
No, I know. That's why I don't understand the second case.
Well, that's all I want is the.
I mean, you think I'm sitting up here and don't know anything.
Yeah.
I look stupid, but I'm.
No, you're very smart, sir.
Oh, I know that.
I would just rather withdraw this case and just go on with the 7th.
You let me know when you're done talking.
Okay, sir. Thank you, sir.
Are you done?
Yeah, I mean, the other attorney,
Apparently not. Go ahead.
the other attorney I was working with before suggested that I do that I withdraw this case and just do the 7-day notice. That's what he suggested. He said that would be easier.
Yeah.
Yes, sir.
Lyman, what would you like to do? So just so that you understand, if she dismisses this case, what I would do is I would pay the escrow over to her, okay, on this case. Now, no, if you dismissed it, I wouldn't be dismissing any of your claims that you have against her. I wouldn't be dismissing any of them with prejudice. You'd be able to raise them in the other one if that's what you choose to do. But that's up to you. And then you'd have to come back on the 7th and we'll see exactly where we are.
I just feel like we should just keep going. We can go this way.
But
Finish it out.
since I'm the plaintiff, don't I have the right to cancel that one, listening to my counsel?
You should have gotten an attorney before you started. But
I know, but that's what he suggested I do. He said,
no, because once she's answered, she has the same right. She can say no.
okay. So if I cancel the one on the 7th, can we just be done with this today? Is that better? I just don't want to keep dragging this on. So if I just kill the one for the 7th and we just,
Ma'am, I can't give you.
well, that's what I want to do.
As to, well, I don't have that case in front of me. It hasn't even been heard. It was filed.
It was just for non-payment of rent, but since you said it overlaps this one, then let's just cancel that one and just do the non-payment of rent on this.
What I'm gonna do. You're gonna stop talking.
Okay.
And then I'm gonna do what I was gonna do at the beginning. And that is, I'm gonna let that other case catch up. They're just gonna be together because you elected to file it. Whether, under what reasoning, I'm not even concerned about that. But I'm not gonna have two cases standing out in this situation. So I'm adjourning this case for its decision to November 18th. When we get to the other case on the 7th, I will try to have that case catch up with this case. And then we can just decide everything, unless somebody wants to file something else in the interim. Thank you.
Thank you.
What time on 18th?
9.
Are we coming on the 7th as well, sir? Okay. Thank you.
You know what? And my good friend, Mr. Lloyd, was sitting there and he wouldn't help me. He just sat there. Just sat there and watched me flail. Nothing like having friends. Did you see that? You did. Yeah, I did. I did too, Joe.
So the two, this is
That's over.
this is good. If you
Is it? I haven't read it.
you have me on his client is in custody, he's gonna have to sign.
Okay, is he back there now?
No, I have to call.
But I mean, is he back and back? He's in our lockup.
Yes.
Okay, so you could take him back. Why don't you go, because I haven't read the report. So why don't you go back, get him to sign off on everything? I'll take the plea. All right. I'll do that. This is a hold out of custody. And how many witnesses?
3, Your Honor.
How many?
3.
Okay. Why do you keep handing me files? I thought we were done.
We are done. I'm done. I'm sitting down. Bye.
Oh, don't run away. Yeah. Ann, I'm sorry. Tana made me.
Oh, hi, Your Honor. These are the last two civil files for both charges. This is the one I do.
Okay.
Right, that's because.
They want it. They can't get to intimacy. I haven't called that one.
Excuse me, Your Honor. I offered the note, plaintiff, I'm not exactly sure, $2,000 within 2 days. Do you know?
Did you propose that to them?
Yes.
And what they say?
I'm not exactly sure what I'm supposed to
What do you mean?
do. Should I go out there and try to talk to them, or should I just wait here and come back and decide if they want to talk to you?
So you have an offer to make to them of paying 2,000 in a couple of days? Go see what they say. I'm never doing this again. Okay, Lacey and Lloyd, why haven't you guys been able to resolve what you have? I would expect two of my most favorite attorneys to be able to just let me know when I'm just gonna keep puffing you guys up until you settle.
Yeah, flattery will get you almost everything.
What? Are you that far apart? Because you're two very reasonable people, but
Can we talk to you for just a minute off the record? Is that something?
yes, so what I'll do, let me have the police report.
I already watched it.
I'll stand in recess, get them back to my conference room, and then I'll come back. What? You don't want me to stand in recess? I saw you turn and go,
That was not directed at the court, Your Honor.
who is it directed at? Alan? Oh, what'd she do? No, never mind. I'm gonna stand in brief recess and then let me try to deal with that and I'll read the police report so we can get rid of that.
All right.
Smiling from the heart, Mr. Cripps. Take care. Have a good day, you guys.
Thanks,
Good
Judge.
luck.
both too.
Thank you. Alvarado. Marcelo Cipriano Alvarado, 25T722251 and 25T722228. Okay. Mr. Ewald. Good morning, sir. Your appearance?
Edward Ewald on behalf of defendant Marcelo Alvarado.
Mr. Alvarado, your name, sir?
Marcelo Alvarado.
All right, so we're just going to go ahead and proceed with the exam next week. It'll be at 10 o'clock in the morning. We should be able to start on time, okay?
Great, thank you.
I'll see you guys next week. And we're gonna, let me just say something here.
No, I do have her in treatment through each.
Mr. Mohammed, wait 1 second, sir. I'm picking you up, I think. Okay, so we're going to do one after the other next week, okay?
Okay, yes.
We got both
Starting at 10.
cases. Proceed to exam November 4th at 10 a.m. on both cases, okay? Thanks.
Thank you.
Have a good day, guys.
Bye.
See you here.
Morning, Judge.
Good morning. How are you, Ms. David? How's things going?
Amazing. How are you?
Doing all right. You're a big shot over there now, huh?
No.
You don't come over and see your district court judges anymore. Give me 1 second. I'm going to take real quick, Mr. Singleton. Stephen Singleton in here. Stephen Singleton, file 25W83750. Mr. Singleton, your name.
Stephen Singleton.
Where you been?
Been anywhere, Your Honor.
You were supposed to pay this a long time ago, weren't you?
No, we put it on a planning book. I'm planning.
Okay, so what brings you here today? Because you missed payments, right?
No, I didn't. I haven't made now, but this month paid. That's why I came in. You told me to come in and talk to you about it. I couldn't pay.
Okay, I said you were supposed to pay 50 per month.
Yeah. Yeah.
Okay, you know what? Yeah, you're all right. What do you want? What do you want to do?
Couldn't pay this month. That's why I came in to talk.
Okay, so what are we gonna do?
I'm gonna pay start again next month. I got to start. paying.
Starting when? The 5th, the 7th?
Yeah, the 7th. Yeah, that's fine.
No problem. You pay 50 per month beginning November 7th. You're right. I see this now. You are correct. I'm glad you came in. You did the right thing. If you need to come in on the 7th too, that's fine, whatever it is. All right?
Okay.
Okay, good luck. Thank you. Have a nice day. Ross Darnell Young, 25B704471.
Good morning, Your Honor. Jessica Davidoff for the people, P86743.
Mr. Nasser, your name?
So sorry, forgive me. Good morning, Your Honor, and to your staff. May it please this most honorable court, Mohammed Nasser, P74485, appearing on behalf of Mr. Ross Young.
So what are we doing here? I adjourned this for an independent forensic exam.
So this is where we're at, Judge, and I had an opportunity to speak to the prosecutor as well. As it relates to Dr. Shiner got into a bicycle accident, requires an MRI, and is delayed. So I've spoken to him. He's reviewed the evaluation from the state. Hasn't tendered his own report yet, but be that as it may, I think this issue may be more a criminal responsibility issue than competency, and competency can change at any time. So at this point, will consent to competency, and I'm just amending an exam.
All right, so there has not been any finding of competency yet. Is that true?
We've had a state report that said he was competent.
Right.
correct.
But I did not conduct a hearing on that because the defense asked for an independent forensic exam. True?
Correct.
That's
Okay, sir, can you tell me your name, please, Mr. Young? I just need you to have somebody help you unmute if you can't do it on your own there.
Okay, perfect. I'm gonna close our case. Good luck. I hope it works out. Yes, sir.
Mr. Young,
Your
your
name for the
name?
record?
Ross Young.
All right, so I've got this report dated the 16th, but I don't think I wasn't the judge that day. Well, yes, I was. I don't think we made a finding of competency, correct?
I don't believe so, Your Honor.
So I'm going to need to have do you agree with that, Mr. Nasser?
I do.
So can you change the date on this or put another sticker on there? Do the parties stipulate to admission of the competency report? Mr. Nasser?
We do.
Yes,
Ms.
Your Honor.
Davidoff?
Yes, Your Honor.
All right. Nobody has any other evidence that they wish to present, correct, Mr. Nasser?
Not at this point, no.
Davidoff?
No, Your Honor.
All right, so I'm going to have that report marked Peoples 1 with today's date. And just give me 1 second while that's being done. So can I indicate the defendant no longer wishes to have forensic exam counsel?
At this point, Judge, yes.
All right. All right, so based upon my review of the report, I want you to do it right on the other one, I think. That's all right. This report has 2 dates, but the October 24, 25 date. Well, today's the 28th. All right, give me 1 second. We have a backup court recorder in here today, guys. So anyway, the court is going to find, based on my review of the report, that the defendant is in fact competent to stand trial, and that's based on the findings of the forensic examiner, who is Karina Rodriguez. My opinion is that Mr. Young is competent to stand trial. I'll indicate defendant found competent based on my review of the report. We're going to schedule this for a preliminary exam unless you want to, let's schedule. I want to kind of schedule this quickly though, ladies and gentlemen. So can you agree on a date? It does not have to be on a state docket day for me.
Whatever date this court has, Judge, I can tell you right now, I'm in a homicide trial before Judge Polis in Oakland County. I anticipate it be completed by either Friday or Monday, the way it's going now. So whatever date works for
the 14th. Can we do the 14th of November?
Your Honor, I am out on the 14th. I'm available on the 11th of that week.
The 11th, the court's closed.
I can do the 14th if the prosecution can find someone to fill in. I'd like to get this done, Judge.
Your Honor, what about the 12th?
You could do the afternoon of the 12th.
Okay.
Okay. Would
You
that
good
be,
that day, 11/12 at 1 o'clock?
Can we make it 1:30, Judge?
11/12 at 1:30. Wait a minute, I got to figure out if that's a sobriety court day. Yeah, it should be. You can't make it at 1?
I'll do my best, Judge. I have a motion hearing scheduled for 11:30 at the Third Circuit Court before Judge Slavins. He's usually pretty prompt. As soon as I'm done there, I can rush right over.
All right, we'll make it 1 p.m. And if you're late, I certainly understand, but I do have sobriety court at 3 that day. But we'll go from there. Okay, so I'll see everybody here November 12th at 1 o'clock.
We'll be ready to. We'll be
Anything
ready.
else?
Nothing for defense. We thank this honorable court and we'll be certainly ready to proceed on 11/12. Thank you, Judge.
Thank you.
Thank you. Thanks, Ms. Davidoff. Good luck, Mr. Ross. We'll see you here, Mr. Young, rather. We'll see you here on the 12th. Thank you. All right. Jeez. People again. Nate and Sarah Consulting, 25SO23343A and B.
Good morning, Your Honor. Who's on behalf of Nate and Sarah Consulting?
So you got a lawyer in the hallway.
Your Honor, what's the only thing that's worse than showing up to the court without a lawyer is showing up to court without a lawyer and then seeing your lawyer at court, that I have to be here. So
I do need you to fill out an appearance.
I'll do an appearance for you.
Okay. Can you hand it to him, Amy? All right. Your name, sir?
Nathaniel Brewer.
All right. So for purposes of this arraignment, does he stand mute and wait formal reading? All right. And then what are we doing here? The misdemeanor of unsafe load is going to be dismissed pursuant to stipulation. And he's going to plead to count 2, right?
He's pleading to us. I was civil infraction that I'm just on the road right now.
Of defective equipment. That's on count 2. I'm not trying to be dense here, but I don't know what he's doing.
There's a civil.
It looks like he's trying to dismiss the unsecured load, right?
Dismiss the unsecured load. He's going to plead to a separate civil infraction.
Of improper tow. I see.
A reduction. We're going to plead to the defective equipment agreed upon.
All right. Is that what you want to do, sir?
Yes, sir.
All right. To the charge defective equipment, responsible or not responsible? To the charge of improper tow, responsible or not responsible?
Clear.
All right. The improper tow plea is accepted. Fines costs on that of $160. Fines costs of $50 on the defective equipment. The unsecured load is dismissed. $210. Can you pay that today?
Good guilty, Your Honor.
Yeah, you don't have it? Okay. Just pay by November 4th. Okay, can you do that?
Yes, sir.
All right, you're all set. Thank you very much.
Yeah, I'll run down.
Good luck, sir.
Thanks, sir.
Yeah, I do need you to fill that out, okay? Have a good day.
One there and they didn't have one.
Malmston, Mindy Elaine Malmston,
Good morning again, Your Honor.
25B 722119.
Apologies. Good morning again, Your Honor. Nicholas Mayor, on behalf of Smallston, who stands to my right, who's standing up for the record.
Mindy Malmston.
Your Honor, we're just asking for one final,
Is this going to resolve or no?
there's a pending divorce case as well, so there's a few different things. We've got some third circuit hearings as well. There was an issue with the discovery. I finally got everything last week. There's a ton of video and things like that, so there was some issues.
I recognize you. My runner. Go ahead. I'm sorry.
Scheduled for a examination as well as a non-violation hearing. However, I spoke to you this morning and I believe we're ready to resolve this case.
That's correct, Your Honor. Should be a plea form in front of you.
Yes, I have a plea form in front of me that indicates that the defendant would be pleading no contest to the charge of stalking. That's a count 2. Count 1 would then, that's a 1-year offense up to 5 years probation. Count 1 would then be dismissed. Defendant agrees to complete accountable choices, the 52-week level 3 program, and start accountable choices while in custody before the pre-sentence recommendation or pre-sentence report. Prosecutor and defendant agree to a sentence of 5 years probation with accountable choices per the above. It's not to be released until a pre-sentence report is or a pre-sentence interview is conducted. Agreement to early termination of probation eligible after 2 years if recommended by probation and the program is completed. There have been no violations. Also, the people agreed not to charge an R&O from the court incident of October 14, 2025. That's the court's full understanding.
That's correct, Your Honor.
Correct, Your Honor, and I've spoken with counsel. I informed him that we do have defendant's phone. It has been extracted, so if evidence emerges from that phone, we might be looking at different charges, whether it's robbery or intimidation. That would be separate. That's not part of this agreement. I want to make sure that that's on the record. That would be a separate charge if we have the evidence for such charge.
That's correct, Your Honor. I've had an opportunity to review that and discuss with him. And we're looking to enter into this agreement today, knowing that.
So, Mr. Sanders, you understand that if from their phone, they determine that there's potential witness tampering types of charges or other charges, that's not contained.
Yes, Your Honor.
Here, so you understand that.
Yes, Your Honor.
All right.
One other thing, bond was not addressed within this resolution with regarding any agreement with the prosecutor. I know they're not objecting to a release after his PSIR is completed. I don't know right now. I understand his bond was revoked. I would
leave it as revoked. Let the interview take place and then lay that in capable.
Okay, and then I'd be able to file a motion fresh hour to amend his bond.
All right, let's have him sworn.
You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Jeffrey Allen Sanders.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charges. That is a misdemeanor punishable by up to 1 year incarceration, $1,000 fine, and up to 5 years probation. You understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, I do.
All right. 2 things about it I have to make sure that you understand. First thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 14A4 District Court.
Yes, Your Honor.
All right. Basis for the no contest plea.
Civil liability, Your Honor.
So, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind. Yes, Your Honor. You signed an advice of rights form, is that correct? Yes, Your Honor. Any questions regarding any of those rights? No, Your Honor. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights that are contained on that form. Yes, Your Honor. You understand you're giving up your right to appeal of right? Yes, Your Honor. Are you on probation or parole? No, Your Honor. Has anybody promised you anything other than what's been stated here today to get you to plead? No, Your Honor. Anybody threaten you or coerce you? No, Your Honor. You're doing this voluntarily? Yes, Your Honor. And of your own free will? Yes, Your Honor. All right. Court has been provided and has reviewed Washtenaw County Sheriff's Office report for their case number 25-43124. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there is a sufficient factual basis which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, that the court would no longer be bound by any sentence recommendation or evaluation. You understand that? Yes, Your Honor. You also understand that you would not be entitled to withdraw your plea. Yes, Your Honor. Is counsel aware of any other promises, threats, or other inducements which have led to this?
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Defense is satisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation is ordered at 1484. Probation sentencing in this matter will be
November 18th at 9 a.m.
November 18th, 2024. Said what time? 9 a.m. That is before Judge Fresh Hour.
Thank you, Your Honor.
Bond will continue as revoked.
Thank you.
All right, thank you. Buck Road, Family Dividend versus Baker.
Good afternoon, Your Honor. Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Name?
Janae Baker.
I have before me a consent order for conditional dismissal that indicates that the defendant would agree to pay $2,000 on him before 5 p.m. on October 30th, 2025. No personal check, only certified funds. Defendant pays on or before October 30th, 2025. Plaintiff will waive the remaining balance. That's basically the court's full understanding, except to make it clear that if you don't pay that, then plaintiff would be entitled to a judgment of the full amount of the including cost of $3,055.63. You understand that, ma'am?
Yes, ma'am. Yes.
Are there any other questions that you may have regarding this conditional order dismissal?
No, sir.
All right, so you understand everything?
Yes, sir.
All right. Thank you, folks, for resolving it. I will sign off on that. Ma'am, you have to advise you, since you are here unrepresented by counsel, you have 3 business days to think about this. If you think that there's some legal reason on your part or some right you didn't assert, you'd have to file a motion with the court within that time frame. You understand that?
Yes, sir.
Doesn't mean that I would grant you have that time to think about it, file that motion. You understand that?
Yes, sir.
All right, very good. Ms. Baker, let me say something to you. Sometimes you can come in with the greatest of all intentions, but I think you could have had this resolved a whole lot earlier had you maybe proposed that to counsel and kind of worked it through, realizing what your potential liabilities may have been in this case. Okay, so if nothing else, I hope not only with regard to a satisfactory settlement of this, that you learned something else from this.
Absolutely.
All right.
Thank you, Your Honor.
Thank you, folks. Beal Properties versus Jason Mitchell. Yes, if he needs more time, then tell him no. just like saying that. Hey, I'm gonna start an exam, so it may be a minute. Bill needs more time. I have to sit here, you know, it's gonna be the longest 2 minutes for everybody. Goodbye, Miss Tanner. Always a pleasure.
Likewise.
Could have said that with a little bit more sincerity, but that's okay. You're done? He's gone. Okay, can you find out kids doesn't? Either way, I need mine turned back on because if I lose that in here, that's not strong enough. But so however you want to communicate it to them. There. Can you find out?
Yeah. I don't know
Jason.
I don't know why it's in the TV. So we've been fine Zoom today, right? I got fixed yesterday.
Did I turn it on again?
Yeah, you did. You didn't say anything, so I guess
Yeah, I
Okay.
didn't.
you didn't notice. Okay.
I did not. It's irritating. Actually, it was easier. But I don't know if that's because of something I did.
Yeah. Okay.
What she said.
She's not responding.
So I never believed Lacey. Her 2 minutes is not 2 minutes. I'm gonna start. Oh, I'm sorry. You were in the room when we were talking about you. Where'd Miss Saxon go? Oh, there you are. Okay, I'm sorry. You were talking to Lacey? Don't. You still need more time? No, I won't make 2 more. Are we ready?
I think we're gonna need to actually have it here. This case number.
Okay, it'll be a minute. Which criminal cases go first?
Got it, we'll wait.
Oh, yeah. Court calls the case of the people versus Gabriel Shawaka.
Water Assistant Prosecuting Attorney for the People.
Seeing Saxon on behalf of Gabriel Shalaka, present to my right.
State your name, sir.
Gabriel Shalaka.
All right. I'm set for preliminary examination. Are we ready to proceed?
Yes, Your Honor.
People are ready, Your Honor.
All right. Let me call you first witness.
Your Honor.
Your Honor, first, I'm asking first, sequestration.
Easy. You just said.
Easy for me to say.
Witnesses are hereby ordered sequestered.
Your Honor, I would ask that the OIC, Mr. Trial be allowed to stay. I do not intend to call him.
Officer in charge may remain in the
You
court.
do not intend to call?
I don't think I'm going to.
There's somebody behind you.
Yes.
All right. May I have it sworn?
Right hand. Charles, swear to affirm the testimony about the truth, the whole truth, and nothing but the truth, so help you God.
Yes, thank you.
See, say and spell your first and last name for the record.
My name is Omaha. OMARMOHAMMAD.
Main court.
Thank you, Your Honor. Mr. Muhammad, I'm going to turn your attention to August 14th, 2025, at approximately 5 to 6 p.m. in the evening. Where were you at that time?
At Zippy's Car Wash on Carpenter Road.
And is that located at 5300 Carpenter Road? And to your knowledge, that's in the Pittsfield Township and within the County of Washtenaw and the state of Michigan?
Yes.
And what were you doing there?
Cleaning it out.
And were you there by yourself?
No, I was accompanied by my sister, Haneen Muhammad.
Could you spell her name for the record, please?
H-A-N-E-N, Muhammad, M-O-H-A-M-M-A-D, and my friend, Talal Al-Maita.
Would you spell Talal's name, please?
I know the spelling of his first name, but not his last. His first name is spelled T-A-L-A-L.
Does A-L-M-A-I-T-A sound correct?
Yes.
And while you were there vacuuming your car, what if anything happened?
So as we were vacuuming our cars, Talal then went to the car wash and came back and parked his vehicle at the end of the vacuuming station, where the entrance is for the vacuuming station at the back of the car wash. And he was waiting for me to finish. As I finished, I was exiting the car wash.
I'm sorry to interrupt you, but just to clarify, you drove separate vehicles?
Yeah.
Okay. So as you were finishing vacuuming?
So as I was finishing vacuuming, I noticed that Talal finished his car wash. And so I was exiting the vacuuming station. And as I was exiting the vacuuming station, I noticed that he was still. And then I also noticed that Michelle was coming into the car wash.
All right, I'm going to stop you there. When you say you were exiting, were you walking or you were driving your vehicle?
I was driving my vehicle.
Okay. And you said Jabril Shawaka. Did you personally observe him?
Yes.
And did you know him before you saw him that day?
Yes.
How do you know him?
He is my brother-in-law's brother.
Your brother-in-law's brother. Could you explain to the court what you mean by that?
His brother, Tepe Shawaka, is currently married but going through a divorce with my sister, Haneen Muhammad.
And Haneen Muhammad was with you?
Yes.
Okay. So you observed Mr. Shawaka come into the car wash. Could you describe your relation, or excuse me, strike that, Judge, I'm sorry. How many times have you met with or spoken to Jabril Shawaka?
Probably a handful of times, probably about 5, I'd say.
And how would you describe the state of your relationship at that time?
At that time, there's a lot of animosity and conflict. And it's an aggressive relationship with him.
And could you describe for the court what you mean by that?
So basically, every encounter that I've had with him in the previous has been very negative. There's been violent threats. There has been multiple encounters of shouting, cussing out my family, disrespect, neglect of family members.
And would this be, what are this animosity related to?
This animosity is related to my sister and Tepe Shawaka, Haneen Muhammad and Tepe Shawaka, having conflict in their marriage and going through with a divorce.
Okay. So with that in mind, when you observed Mr. Shawaka come into the car wash, what happened next?
After that, I noticed that he was glancing at me very inappropriately, and he gave me an inappropriate hand gesture.
What was that?
Middle finger, which I reciprocated. I apologize to the court. That was not the best behavior of my end, but I reciprocated that with the same hand gesture.
It's a free country. You have the right of expression.
Staying.
After you exchanged gestures, what happened after that?
After that, he continued to drive forward. I noticed that Talal was still parked at the same spot where he parked the parking station is.
Mm-hmm.
And he drove forward, and there's like
I'm going to stop you. I apologize. When you say he drove forward,
so
you're referring to whom?
he drove past me.
Whom? Who drove?
Sorry, Jabril Shawaka.
Okay.
Past me. And he stopped at the island where the entrance and exit is for the vacuuming station. And he parked his car and got down.
And where was he then relative to you and to Mr. Almeida?
He was in between our cars.
Okay.
With his vehicle parked
Okay. And then what did he do?
to the left. Then he exited the vehicle. I also exited my vehicle. After that, Salal was probably outside of his vehicle, wiping it down or something. So I exited my vehicle. And noticed that Salal was not out of his vehicle yet. But Jabril Shawaka was out of his vehicle. And his door was open. And
Which door?
his driver's door.
Okay. And then what happened? What did he do next?
When I got out of the vehicle, I next noticed that he started reaching for a handgun that was on his driver's side door.
So when you say reaching, he was reaching towards the driver's side door.
Yes.
All right. And then when did you observe a handgun?
Yes.
All right. When you observed that, where was it?
It was in his right hand and it was pointing at me.
Describe for the court how he was holding it and how it was pointed at you, please.
When he grabbed it with his driver's side door, he reached down and grabbed it and he picked it up. He brought it up to his waistline and pointed it directly at me.
Was his arm fully extended or was it down at his side?
It was down at his side.
And his forearm was raised?
What do you mean by forearm?
This part.
Yes.
Thank you, Your Honor. And at that time, did you testify that the firearm was pointed at you?
Yes.
All right. What did you do next?
I then next raised my hands.
Why did you raise your hands?
To be honest, I was in fear that I was gonna get shot. And I was also making myself noticeably that I was defenseless and had no weapons on my person.
Okay. And then after you did that, what happened next?
After that, we were exchanging words and I was basically saying some inappropriate terms, kind of to question his courage, to kind of motivate him to lower his weapon so I could be out of the state of danger. And then I turned around and noticed that a black truck with 3 other guys, a black PMC, approached and got down from their vehicle.
At the time that you turned away, was he still holding the firearm?
Yes.
Excuse me, Your Honor. So as you turned and walked away and the other car came in, what happened after that?
After that, they, 3 gentlemen in that black truck got down from their vehicle and started to approach me.
What do you mean they got down? They got out of the vehicle?
Yes, so my truck was parked at the exit of the vacuuming station and they came and parked beside me, the black truck. And 3 guys, I don't know who they were, got down from the vehicle. And they got basically in between me and getting back into my car.
And then what happened?
After that, they started talking to Jabril and they started talking to me and kind of getting in between me. I was just trying to get my sister back in the car. I was yelling. I was police, let's get out of here.
Were they all speaking English?
Yes.
Okay. And what were they saying back and forth?
They were, the only thing I remember was them saying that they know Jabril and that he's very problematic. That was one of the statements I remember. Other than that, I don't remember much.
All right. So after they said that, what happened next?
After that, Jabril started to approach us where they blocked me off. And then he went and he standing behind the 3 gentlemen that approached me. And
who was standing behind him?
Jabril Shawaka was standing behind the 3 gentlemen that approached me from the black truck.
Okay.
After they approached me and they were all huddling around me. And then he got behind one of them and reached over, Jabril Shawaka reached over one of the guys and punched me in the face.
And then what happened?
And then I punched him back.
And what happened from there?
After I punched him back, I punched him a couple times. And then I got back and I started looking for my sister, telling her, let's get back in the truck, let's leave. These guys are very violent, they just attacked me. I also noticed that employees from the car wash started to approach to see what was happening, the situation. And I was just very frantic and trying to leave.
And then what did you do after that?
I gathered my sister, my friend, Tal, myself, I knew Muhammad, and we got back in our vehicles and we started to leave. I got back in my truck and put my car in drive and started to leave the car wash. I went to the front of the car wash and Tal pulled beside me in the front of the car wash. And he was trying to ask me where the car wash was because he was on the phone with police. And I responded to Carpenter Road, but he didn't hear me.
And then what happened?
After that, he parked beside me in the front of the car wash and he got down from his vehicle and I got down from mine. And when I got down from my vehicle, I noticed that a deep Shawaka came into the car wash and blocked our trucks.
Who is Adib Shawaka?
Adib Shawaka is Jabril Shawaka and Adib Shawaka's brother.
Is this the person that is married to your sister?
No, Adib Shawaka is the brother. Adib Shawaka is the one that's married to my sister.
So this is a different brother.
This is a different brother.
And how he arrived in a car?
He arrived in a black truck.
And where did he park that car?
What?
I'm sorry?
He arrived in a
Black Ram truck.
And then what did that truck do?
It came and it blocked off our trucks from exiting.
And then what happened after that?
After that, I seen that my friend Michael was getting down from his truck. So I told him to get back into his truck. because I realized that now there's danger. There's two guys. Possibly both have weapons, you know. And
What happened?
Speculation.
Oh, but that goes to his state of mind, not taking it as a fact. So overrule the objection. I'll let the answer stand. Go
Thank
ahead.
you, Your Honor. So what happened next?
After that, I was telling Paul to get back into his truck. And as I was getting back into my truck, Jabril Shawaka came out of nowhere in my sight and opened, pried my door open as I was shutting it, grabbed me by the legs very viciously and told me, "I got you now," and then proceeded to punch me in my face.
And then what happened after that?
After he punched me in my face, my recollection is that I rendered unconscious for a moment, because the next moment I woke up, I noticed that Jabril and Adib Shawaka were on top of Talal Maita, hitting him, kicking him, punching him in the flower bed across the parking lot to the car wash.
So you testified just now that you think you lost consciousness briefly?
Yes,
When you regained consciousness, where were you physically?
in the truck.
You were in the truck.
Yes.
And then after you observed Mr. Almeida engaged in a fight with some other gentlemen, what did you do?
After I seen that they were kicking him and punching him and being very violent, and I got down from my truck and I started to approach him to try to go help him.
Mhm.
And then I noticed that they just left him alone, and then Jabril tried to charge at me again. And then I took a step back.
When you say Jabril tried to charge at you, where was he standing?
So that was in the flower bed, which is where the mulch.
I understand.
So basically, they were hitting Talal, and then as I got down from my truck and started to approach, they both got off of him, and then he kind of like jolted himself forward at me.
And then what did he do?
I then took a step back. They both ran off with their vehicles. And then from which there, Jabril got into his vehicle. Jabril, when he was leaving, tried to hit me exiting the car wash.
Can you explain to the court how he drove that made you think he was trying to hit you?
When he exited the car wash, he turned the car facing towards my direction. And I kind of took a step back out of the way, and then he corrected the steering wheel to exiting the car wash.
And in the course of him doing that, did you think he was going to hit you with the car?
Yes.
After that, what happened next?
After that, they left the car wash, and I frantically tried to take out my phone to take a picture of the license plates because they were fleeing the scene. So I wanted to gather some information.
Okay, and then what did you do?
I went over to Talal and helped pick him up off the floor, started brushing off the wood chips off his back. And then after that, I believe
the police arrived after that, you said?
That is yes.
Yes.
And then after the police arrived, you spoke to the police and explained what had happened?
Yes.
Your Honor, may I have just a moment, please? Thank you, Your Honor. I have no further questions for Mr. Mohammed.
Cross-examination.
Sorry.
Go ahead.
So, Mr. Mohammed, you stated that when you got to the car wash, you and your sister Haneen were in one vehicle.
Yes.
Talal was in another vehicle. When the police arrived, Haneen was no longer at the scene. and she had left in a green Cherokee, correct?
No.
She was still at the scene?
Yes.
So you are aware that all officers had body worn cameras on and activated during this whole interaction, correct?
Yes, sir.
Okay, so Haneen was never interviewed at the car wash.
Objection, speculation. How's he supposed to know that?
Well, then he can say he doesn't have. Objections over. Go ahead.
Do you own a green Cherokee?
No.
What vehicle were you in when you and Haneen arrived?
I was in bullet silver Dodge Ram 1500 years 2024.
And did Haneen call the police?
Talal might have told the police to my recollection.
And when you left the car wash, did you leave with Haneen?
Yes.
What was Haneen wearing that day?
A black scarf. That's my recollection. I do not remember. I'm not good at remembering what clothes he wore.
So do you recall speaking to multiple officers while you and Talal was standing next to each other?
Yes.
Where was Haneen standing?
She was next to my truck. I believe so.
So you've stated your testimony was that you and Jabril had a contentious relationship, correct?
Define contentious.
Confrontational. You had a handful of interactions that were negative.
Yes.
Okay. And in fact, both families have had negative interactions with one another.
Yeah.
There's 3 instances where police have been involved, where both families were having negative interactions, correct? At least 3.
To my recollection, do you want me to explain or?
No, yes, no question.
Yes.
Okay. And those interactions have taken place prior to this incident at the car wash. And during those confrontations where several police were involved, it was because of threats being made by you and your family.
By Jabril.
No, my question was by you and your family.
No.
No, never?
I'm sorry?
You guys never made threats against them?
No.
Okay. And you've made threats against Jabril over the phone and in person?
No.
Okay. So you don't recall ever saying to Omar prior to this incident even?
I'm sorry, saying to Omar?
Correct. No, to Jabril. You saying to Jabril, inviting him to meet you at a location.
Yes.
Okay. And adding on, I'll take you and everybody out.
No.
And you're going, I'll kill you. You don't recall ever saying I'll kill you to him? And you realize that you were sworn in at the beginning of this, right?
Yeah.
And so all your testimony needs to be truthful.
Yeah.
If it's found not truthful, that's perjury. And that and you
You
realize
don't have to give him a lesson on counsel. I think that's inappropriate.
encouraging, incentivizing him to make sure he's telling the truth.
Well, you could ask him that.
Okay.
I suppose he knows what an oath is if he took it. But I don't need, because your statement of law regarding what is actually incorrect. But go ahead.
And you state, so if we play a recording of you making those statements, it wouldn't be accurate, is what you're contending.
So,
Okay. So when Haneen spoke to the police, she stated you gave Jabril a middle finger. Was that the truth?
yes, I reciprocated.
First. Her statement was that Jabril came in and you gave the middle finger. So you're saying that's not true?
I reciprocated the middle finger to Jabril, showing he has.
Okay, so her assessment was false.
Judge, whose assessment are we talking about?
Haneen,
Haneen hasn't testified. So he's testified that Jabril gave the middle finger first.
I believe he opened the door to the question when he brought it up during your questioning of him.
He said what had happened, Your Honor. This is improper impeachment. He's trying to impeach him with a statement that somebody else allegedly made that hasn't been brought into court.
Sustained.
Thank you, Your Honor.
So you had an opportunity to leave the car wash when you saw Jabril coming, but you did not leave.
No.
You did not have an opportunity to leave?
No.
You were in the car, in your vehicle?
Yes.
And what kept you there?
Reassuring that my friend's safety of him leaving the car wash and acknowledging that Jabril Shawaka was present at the car wash as well.
But the confrontation, the issue between you and Jabril was only between you two. There was no history of Talal and.
That's no.
There were no issues between Talal and Jabril.
No.
And at the car wash, you gave very detailed statements to the police officers. Do you recall that?
I believe so.
And at no time had you ever mentioned an attempt to hit you with a car by Jabril until today.
What?
Was that a question?
Correct. He said, okay, before I said correct. So it was answered. For the first time also today, you mentioned 3 guys in a, did you say GMC or AMC?
It was a GMC truck.
And you did not know who they were?
No.
And were they there when the police came?
Yeah.
And you are aware that the police got names of witnesses, correct? But there's no mention of 3 guys in a GMC. So you did not point them out to the police?
I pointed out that there was 3 guys in the GMC.
And you pointed to them and said it was them?
I don't recollect. I believe they might have left the car wash when the police arrived.
Well, hold it. You just said they were there.
They were there. Well, when the police arrived, they might have been there. I was very.
No. The question was, were they there at the time the police arrived? You said yes.
I believe they were. They were parked on the side. When I noticed afterwards, when the police arrived, they were parked on the outside of the car wash. When you enter the car wash from Carpenter Road, they were parked on the side.
Whatever they say, I'll send to you.
Near the other businesses.
And you had not seen them before that day and, excuse me. That was one of the vehicles that was in the driveway when Adib, Shawaka, Talal, Amita's vehicle and your vehicle were all in the driveway.
I'm sorry, can you say that?
That GMC was in the driveway along with your vehicle, as well as Talal Amata's vehicle and Adib Shawaka's vehicle. All 4 were in the driveway.
All were in the back of the Zippy's car wash. In the parking.
But when you said you weren't able to leave because you were blocked in, wasn't that one of the vehicles that was blocking?
I was blocked in when we were exiting from the front of Zippy's car wash. He showed up and blocked our truck off from the front.
Were you able to give a description of these three gentlemen that we're just now hearing about for the first time?
Their ethnicity.
No, I'm saying, were you able to give one to the police, a description of them? Because there's no description in the police report.
If I did, I might have.
Did you tell the police about these three people?
I did, yes.
Okay. Did you tell them when the police arrived that they were there?
Yes.
When you told the police they were there, what did the police say to you about that?
They told me if I
that what?
I'm trying to recollect what that day. When the police arrived, I believe they asked me if I knew them. I told them no.
Knew them being who?
Well, the three gentlemen in the GMC, the black GMC truck. I think I recollect them asking me if I knew them. I told them no, but they were there. They got down from their vehicle. I recollect telling them that when they got down from the vehicle, I was very scared. I thought that all of them were approaching to attack me. And that's about all I recollect telling the cops about them. But I definitely mentioned that there was three guys in the black truck there that day.
Go ahead, Mr.
Being that you and Jabril have had a contentious history, there's been a lot of back and forth, you admitted to. You recall threatening him as well, correct?
No.
You never threatened him? Okay. And 12 days before you were arrested for CCW, correct?
Objection. Relevance.
Relevance.
Mr. Shawaka is charged with felonious assault as one of the three counts. One count is felonious assault, 2 assault and batteries. Knowing the history between Omar Muhammad and the family with them, if there was,
I'm going to sustain the objection because I'm not going to have this talking answer to it. You either
if
can
there's
answer, you
a,
don't.
it's
Objection
relevant.
sustained. Ask the next question.
If there was a weapon shown, would it not have been in fear based on the threats you made to him prior?
No.
And knowing that you carry concealed?
Objection, Your Honor. She's asking you to
sustained.
While you said you were fighting Jabril, you said Jabril was fighting Talal. How did this happen? You can't fight two people in separate places at the same time.
Objection. She's misstating what he testified to.
He said Talal was in a flower bed. He said that the three men, Jabril was standing behind the three men by the vacuums.
That's not what he testified to.
What's the question?
That Jabril could not be fighting two people at the same time. So I'm trying to get how did this happen? How could he fight two people?
Rephrase. I'll sustain the objection.
How many times did you have physical contact with Jabril at the car wash? Meaning?
I think as in him hitting me.
Physical contact.
Physical contact as in him attacking me.
Hitting, whether you hitting him 2 times?
He hit me.
How many times did you hit him?
Did I reciprocate?
No.
How many times did you hit him?
I hit him twice in the face.
At one point, it was said that you were kicking. While you were in the car, you were kicking at Mr. Shawaka, Jabril. I'm sorry, I'll use first name since there's two Shawakas, if that's okay. Was that not a true statement?
Judge, he didn't testify to that, Your Honor.
He did say-
I'll allow really? That's twice. Don't cock your head toward me, counsel.
I'm listening to you.
We're going to stand in recess. You may step.
All rise.
I have a problem. You have that way.
With upload.
All right, here's what I'm gonna do. I'm gonna give you 3 weeks. We're gonna set it for the 18th, and I'm also gonna set a jury trial. Call in the prosecutor, unless you think you're gonna waive it if you don't go forward. If you don't resolve it, it's up to you. I can just give you a jury date now. Call in, is this Miss Elway?
Yeah.
Yeah, call her in. She,
May waive once I talk.
that's fine.
Yeah, I don't want to waive that.
I got it. 237, John.
I got it.
So I'll adjourn this. Why don't you give me a time, November 18th, Lisa?
9:15.
Yeah, he needs 10. I'm good with 10.
Okay, 10.
Southgate.
That's fine.
So I should be here.
And then we'll set a jury trial date. I got to just make sure that she's good with whatever date we have here. Good morning. How are you? Good. Your appearance? So we're setting a final pretrial for November 18th. We're closed the 11th, but I also want to set a jury trial. I want to set one for like December, either the
5th or 12th.
5th or 12th. So can you guys pick a date, one of those?
Yeah, it's on the 12th, so it's the.
How about the 5th?
I have trials scheduled on for.
How about the 19th?
I love my computer there. It's giving me.
Go check if you need to. Come on, I'm going to pass the case. Fill out your appearance on the other one. As soon as she comes in, we'll pick a date, okay? Do I have something else out here?
Is there another date after the 19th that we're?
Oof.
I mean, I know this isn't gonna be one that you're gonna be overly late, but that's our whole company Christmas.
Oh, I got it. We'll see. We'll figure something out. I don't want you to miss your Christmas party.
Yeah.
Ms. Tucker, what do you have?
Good morning. I have Andrew Stephen Siak, who is
Did you
present.
talk to Mr. Mohammed yet?
I have not. I need to.
Okay, we'll put you in a breakout room with.
Thank you, Your Honor.
What do you have? We're back on the record on Malmston, 258-722-119. Come on up to the podium, ma'am. Ms. Alloway, what do you have?
December 12th, they do trial.
You can't do the 5th?
The 5th, I also have a trial in Tepe. Would be a jury trial, which is,
Do you have any other day of the week you can give me or not?
Thursdays typically work for me.
Really?
Yeah, and the Wednesdays and Thursdays, I'm in the office, so those days I can do the jury trial at work. Is okay with doing a jury trial on those days.
What do I have on the 4th, Lisa? Trenton?
I have a trial with Judge Giroux.
What about the 10th?
December 10th, you have Woodhaven and Rockwood. I'm sorry, just Woodhaven.
Let's do it on the 10th. You guys good on the 10th?
That works for me.
So we'll start at 10 o'clock in the morning, okay? December 10th. I'll make it 10:30, so we'll start at 10:30 in the morning on the 10th promptly, okay? Is that right?
That works for me. I just want to make sure it works for the funds.
Yeah, he said it does. So December 10th at 10:30, and we're gonna have to finish that way, okay?
That's fine. And I'll let the court know once we may switch it to a bench.
I got it. No problem. Thanks.
Thank you very much, Your Honor.
You can go down the hall, get your notice, and they'll give you a appearance form on the other one. Mr. Mohammed, do you have something else? I got a couple of lawyers out here.
Yeah.
Sir, do you have a case in here? What's your name, sir? Ma'am, what about you? Do you have a case? Okay. Okay. Francesco Juarez, hope I pronounced that correctly, 25X 459 7126. Yeah.
Up at the George house.
Yeah.
I've already adjourned this, haven't I, a few times or not? Your appearance?
Are you referring to me, Your Honor?
Yeah, I need your appearance.
Oh, sorry, I didn't hear it called. Bradley Ruffner on behalf of Mr. Karaj here. No, this is our first hearing. It's never been adjourned. We did have a chance to speak. I do have my client here with me as well. We spoke with the prosecutor, and he's asked for a 2-week adjournment in order for my client to complete the online driver safety class.
I don't know how many times I got to tell him I don't want to do this. I really don't.
I'm sorry, Your Honor.
I need you in here, please.
Typically I don't know, in other courts I've had where you don't need an adjournment, you just have to complete the class and then
Whatever, I just don't believe in, your name?
Good morning, Your Honor. Mohammed on behalf of the people.
I really don't want to adjourn these for class completion. I think I've kind of made that clear to you.
I think typically you have
listen, I'm sure there's other judges in courts that do that. I get it. It's okay. They can do what they want to do, but
Your Honor, I did extend a plea offer of 6 to 10 limited speed, and defense was requesting that the 1 to 5. I said the only way possible is if there's completion of that program.
Okay, I don't want to do this with classes anymore. I'll do it on this one.
Okay.
I just appreciate it if you'd not do it with classes.
Understood.
Okay? All right, so I'll adjourn this 2 weeks. Well, we can't go 2 weeks, can we? We're going to go to the 14th. You're available the 14th, right? You're going to be here, right?
Yes.
No, adjourn to November 14th. We can just make this, Lisa, at 8:30,
Yes, that's fine.
and that'll give them chance to complete the program, okay? But no more adjournments though, guys. No more adjournments.
Reach out on the 14th, so I might not be here, but I'm sure someone from my office will be, and I will on the page.
Right.
Exactly what the patient be.
Okay, so that's what we'll do. All right? Anything else, Mr. Ruffner?
No, I appreciate the courtesy.
Have a good day. Thank you.
Thank you.
Are you just observing or do you? Okay. No problem. Do I have anything else that's ready here? Might as well go off the record. I don't think we have anything imminent here. Okay. Quite a game last night, I guess. I fell asleep.
Fell asleep with the
18 innings. It's crazy.
a lot of blown calls.
Was there?
Final should have won that game 3 times, right?
Really?
Yeah, bad calls.
Well, we don't have to sit here when nothing's going on. Lisa, will you let me know in chambers, please, when something's going on?
You don't want to break something.
Pardon?
I'll let you know.
Okay, thanks. You can stay seated, ma'am.
Yeah, that's too bad. Yeah. Too much. Yeah. Yeah, I just see some highlights past 9 years.
It is clear from the video that the paperwork here and you can see a surety bond was, well, that's 2 weak. And then another indictment, aggravated assault with a deadly weapon. That was another $2,500 bond.
Let me go check.
He has 2 cases from this incident, Judge.
Yeah.
Also showing that he's got a California sentence for 36 months, Judge.
For what?
Excuse me, Judge, it's 36 months probation, not a sentence. And it is it's for driving on license suspended.
It looks like these two indictments came out, grew out of the manslaughter case. I guess the driver was killed, or one of the occupants, and the other occupant was injured, and that's the aggravated assault. So the two occupants in the vehicle that were struck from behind by the defendant are the substances of these two second-degree felonies. Each of these carry with it up to 20 years in prison. We're looking at the public safety report that the court has been provided on the defendant. Criminal history reports. What state say? Yes.
Judge, the nature of both these offenses, I'm concerned with the amount of bond that was set on them.
I did.
And there's a loss of life here, and it's not my case as Mr. Laird's, but just looking through the carnage on the highway, I can see why it is that we filed the charges in the fashion that we did, and bond sure don't reflect the seriousness of the offense.
Okay, according to the probable cause affidavit, one occupant was killed, the other was severely injured. And it's $2,500 in each case. That is woefully unsatisfactory and inadequate. What's state saying?
Judge, what I've seen for these kind of cases is an amount that ranges anywhere from $50,000 to $100,000 that the court has set previously. That's why I'm sure that's why it was brought to your attention that the bond needed to be addressed. I think, in fairness, even though the criminal history is limited to the incident that I was describing to you, the need for the safety of the community requires that the bond be raised to substantially from what it is right now.
Well, the defendant was indicted for recklessly causing the death of one individual and intentionally, knowingly, or recklessly causing bodily injury, and it reads was severely injured in the probable cause affidavit, but nonetheless, that's what aggravated assault with a deadly weapon. It doesn't need to be severely injured, but those are when you're operating a missile on the roadway, like we all do, it has to be operated responsibly, not recklessly, not even negligent, much less knowingly or intentionally involved in a collision. So, Don, I'm going to raise the bond. It's just a matter of what. I mean, this is not even. It's really not at all reasonable under these circumstances. I don't know what the judge used in its determination, but this is clearly not something that is reasonable. So are you asking?
The only comment I would make to the court is that, he's a professional truck driver. We don't have any prior incidents, anything like this to my knowledge. He's been on this bond, even though it's low, since the date of this incident. He's not gotten in any trouble. He hadn't done anything. He's probably not qualified for a court-appointed lawyer or because of his income and his profession. He's in the process of hiring a lawyer, and if you set the bond too high, the money that he's going to be used to be hiring a lawyer may instead go to a bondsman, which I think kind of defeats the purpose of people having to provide him an attorney when he's qualified to hire one. Nothing's happened. Let's see, the date of this thing was in March, so we've been 6 or 8 months that we haven't had any problem with him being on bond with the amount that's there. So, I understand that court's concerned, but, he's had several months to show that he hadn't, and that's what he's asking the court to reset his case so he can get his lawyer.
Your bond is raised to $50,000 on each case. We have a death and a serious bodily injury, a severe bodily injury. And this is where a gigantic missile struck these people from behind. And I'm reading the probable cause affidavit, and it's bewildering that you didn't see what was happening in front of you.
It was actually a collapse.
Grand jury didn't see it as accident, so grand jury indicted you.
I also know the medical everything I said, I never been going before. It's the exact foot to hire a lawyer so I can come back in.
Somebody died. A human being's life was taken.
Right. And
do you find that important?
Yes, sir. Yes, sir.
Another person was the other part of the married couple is severely injured and has lost their spouse, struck from behind as they were stopped on the roadway. Do you see anything odd about this that needs serious thought?
Yes, sir.
Oh, $50,000 on each case is the bond, and not only for the circumstances, but it's just humane. A life was taken. You're allegedly reckless in your actions in each of these cases, at least reckless. The grand jury also stated intentionally or knowingly.
I had brakes. So
For recalls case, Beal Properties versus Jason Mitchell.
Good afternoon, Your Honor. Gabriel Lacey for Bill Properties.
So Lloyd, Your Honor, appearing on behalf of Mr. Mitchell, was in court with me today.
Your name, sir?
Ms. Jason Mitchell.
All right. I have before me a consent judgment that indicates that there's a money judgment for two things. One is that the defendant will vacate the premises 12 a.m. on the 29th of October 2025. There is a money judgment, total amount including cost of $20,000, and indicates defendant shall leave keys on the bar at midnight, 12 a.m. on October 29, 2005. Oh, this terminates the lease and settles all claims. That's the court's full understanding of the agreement between the parties. Is that correct, counsel?
That is correct, Your Honor.
That is correct, and
Correct.
you understand?
Yes.
Questions?
All right.
Good for now.
Thank you.
Do you have any other questions regarding, you had counsel, Mr. Mitchell, but do you have any other questions regarding this?
I think my questions are satisfied.
All right, very good.
Thank you, Your Honor.
Thank you.
Thank you folks for working it out. I've signed that.
Thank you for your help.
Thank you. Sometimes cases are like baking bread. You just have to leave it in the oven. We're back on the record in the case of the People versus Chihuahua.
Jonathan Water, Assistant Prosecuting Attorney for the People.
Tina Saxon for Jabril Chihuahua.
Sir, I just remind you that we've taken a break, but you are still on the roll. You understand that?
Yes.
All right. You need to inquire, Ms. Saxon.
You did not request medical attention at the car wash, correct? And you did not tell the police that you had lost consciousness at the car wash while being interviewed at the car wash?
I don't believe it.
Okay, no further questions.
Can you redirect?
Just briefly, Your Honor. Regardless of what you had told the officer, approximately how many times did you get punched or kicked or hit?
Punched 2 times. The second time, I was told I got punched directly in the center of my face, and it was very powerful.
And you lost, you testified you lost consciousness?
Yes.
And how were you when you were being interviewed with the police, were you feeling the effects of that?
My head was buzzing, my nose was bleeding. I felt very sharp pain in my nose, and it was like I was very foggy.
And at the time when the police were interviewing you, can you recall how many police cars were there?
No, actually I can't.
Can you, no idea?
I believe there was probably more than 2.
More than 2? Okay.
More than 2 or 3.
And how many people do you recall being around at that time?
When the officers were there?
Yeah.
I'd say there was at least probably like 4 or 5 officers.
Okay. No further questions, Judge. Thank you.
So was the defendant there when the police arrived?
No.
He had left.
Yeah. They both left.
They both being who?
Real show that the deep show.
So.
And then after which a whole bunch of people came as well. And there was people.
After a whole bunch of people from where?
I noticed that there was black Range Rover that they told me that was their uncle that was there. There was a blue BMW.
Whose uncle?
Jabril and Adik Shalaka. They told me that was their uncle that was there. They told me that, and then after which there was a couple other guys that I remembered from the wedding. Their last name were Kat. They arrived after which when the cops were interviewing me, and also Adik Shalaka came afterwards. And there was a couple other guys that I don't know that were also there that came to park on the side after the fight. They were like still arriving.
The 3.
When Jabril was pointing the gun at me and then.
Your Honor.
Yes.
Will we get a chance to, redirect or not redirect, cross on what he's just stated?
You've had his answer for me. I certainly will give you an opportunity.
I have no.
to do it, but I have to clarify. Yes, you have.
No, I haven't.
You have. It was memorable for me. Sir, what I'm trying to figure out is you testified that prior to the police arriving, the defendant had left, correct?
Yeah.
Okay. The 3 people that were in the black vehicle, were they there for the defendant, in your opinion?
In my opinion, I believe so.
Okay, so, but when the police arrived, they were still there.
I don't know. I believe they were.
But hold it, you testified that you pointed out those people to the police.
Yes, because they were on because I think one of the officers approached me.
Sir, hold on. They're either there or they're not. So if they're not there, how do you point them out to the police?
They were parked on the side of the car wash. When you exit the car wash, they were parked on the side. So they were there.
So now what you're telling me is they were there.
Yeah.
And you pointed them out to the police.
Yeah.
Coming to the car wash, in your vehicle, there's you and your sister.
Yeah.
And then your friend is in another vehicle, right? Did you all arrive at the car wash at the same time?
My friend did.
Pardon?
My friend did meet my sister.
Yes.
Yes.
Okay, so you all drove to the car wash.
Yeah.
Did you get your car washed?
No.
But your friend did.
Yeah.
You just were vacuuming out your vehicle.
Yes.
What night of the week was this? It was August 14th.
Thursday.
Immediately before going to the car wash, where were you?
Leaving my house.
Is that in Pittsfield?
Yes, it's on Texas.
And where were you headed?
I was heading to the car wash.
Okay, and after you went to the car wash, where were you intending on going?
Back to my house.
Does your sister reside at the same house you live in?
Yes.
So your sole purpose in going out was to go to the car wash to vacuum out your vehicle?
Yes. Well,
where was your friend before? Was your friend at your house?
no, my friend was at his house. He was coming to meet me at the car wash.
Where's he live?
He lives in Ann Arbor.
Okay, so can I ask, where was he going to your understanding after the car wash?
Also back to my house.
Was there a particular reason why you were meeting at the car wash?
Yes, we went there to clean out our vehicles because my sister wanted to go to Chicago. But because my aunt lives in Chicago, so she was going to visit her aunt. But because I can't leave the state currently, we agreed to go clean out our trucks because he needed to clean out his truck. And then he was going to proceed to take my sister to Chicago.
And you can't leave because of some bond condition?
Yes.
Just so I have it straight. Your sister wanted to go to Chicago.
Yeah.
You can't take her to Chicago. So your friend was going to take her to Chicago.
Yeah.
And so rather than have your friend come to your house to get your sister, you decided to meet at the car wash.
We were just going out to clean our cars, yeah.
You were just what?
We went out to clean our cars beforehand.
Well, hold on. You said you were meeting at the car wash.
Yeah, we met at the car. So the whole day, it wasn't planned. It wasn't like, because it was all very like sudden. Because at that point, my sister had just gotten into a fight with Steve Shelka. And
with who?
Steve Shelka.
Her
current husband. That she's getting a divorce. So they had gotten into a fight, and she had came to stay at our house. And so she wanted to go to Chicago. She was talking to my aunt. She wanted to go to Chicago.
Okay, when was the fight?
I'm sorry?
To your understanding, when was the fight?
What's the fight? August 14th.
Between your sister and her husband?
Between her sister and her husband? My sister and her husband?
That was
beforehand.
Like a few days beforehand, few weeks, few months?
I'd say about a week and a half.
Okay. And so then she was going to Chicago.
Yes.
When you say it wasn't planned, what wasn't planned?
So all the details weren't planned, like how she was gonna go to Chicago, how we're gonna get her there. So throughout the day, we were just making like a plan how we're gonna get her to Chicago, and she wanted to go. It was either her taking a train, taking the Amtrak to go to Chicago, and my aunt picking her up in the Amtrak. Or they proposed that I take her, but I said I couldn't because of my bond. And then I called my friend Paul. He said that he might be able to go. So we met up at the car wash. It was just like a whole bunch of like planning to try to get her to Chicago. And that's how we ended up at the car wash at 6 o'clock.
When you arrived at the car wash, or prior to going to the car wash, did you know defendant and his family would be there? Be careful how you answer that question, sir.
No, Your Honor.
You did not know?
No.
So at the point at which the first member of his family that you see is him?
Yes.
Okay.
Your Honor, sir, could you repeat that in here?
My last question, the first member of his family that you saw was the defendant. I guess it's a better way to put it. As I'm listening to your story, was there ever a point that you believed that you could leave the car wash?
No.
So at no point could you have driven out of that car wash?
Based on the events that happened, I was trying to leave the car wash. That was my main.
Sir, that car wash is off of a service drive off of Carpenter, right?
Yes.
And so from part of the lot, at any given, you're in a 1500, right?
Yes.
Four-wheel drive?
Yes, sir.
At any given point, you could have driven down onto that service drive, right?
Yeah.
Yeah. Isn't that correct?
Yes.
Any questions based upon the court's questions?
May I ask just?
Go ahead.
If you had left, would you have left your friend then?
I would have left my friend in the
And do you see Jabril Shawaka in court today?
Yes.
Could you identify him based on what he's wearing and where he's seated?
He's seated right next. He's seated right over there. He's wearing a black jacket and the gray tie and a gray dress shirt.
And I ask the court to reflect the in-court identification of Mr. Shawaka.
Record shall so reflect without objection. I, based upon your question, and I'll let you follow up, but where is your sister while all of this is going on?
She was in my passenger seat. In my But like she got down from the vehicle.
When?
So as soon as I got down from my vehicle to make sure that the law was like had knowledge that it's there, let's go. She also got down from the vehicle at that point as well. So we were
Couldn't you see your friend? When you're in the vehicle, after you guys exchange greetings, can't you see your friend?
from when I was leaving.
You come in.
I couldn't see.
You,
When I was leaving, I couldn't see my friend. Because he was still parked behind me. I was leaving the vehicle, he was still parked. The car wash, was in the car wash. So
before you got out of the vehicle, could you see where your friend was?
I could see where the car was parked. But I couldn't see him physically. No.
Why?
I was too far away.
You're 2 vacuums down, right?
No. So at that point, when I got down from the, you were exiting the area where the vacuums were. From the back of the car wash. So I'm going to the front of the car wash, I'm exiting, and he's still parked behind me on the corner.
And Your Honor, my recollection was at this point, his friend had finished vacuuming and gone through the car wash. So he was parked in that lot, but not at one of the vacuum stations.
But I understand, but at some point he comes. Did you exit your vehicle before your friend came out of the car wash?
I was, when he came out of the car wash, I was out of my vehicle. So I was still vacuuming my car. When he came out that moment. And then he proceeded to park in the lot where the vacuums are.
Right.
I finished vacuuming my car. I got into the car, I'm leaving, and he's still parked.
Were you, may I ask a question, Your Honor?
Yes.
When you got back in your car and you said you were leaving, were you then going to go through the car wash as well?
Leading objection, Your Honor.
Sustained. It was so leading because he. Go ahead if you got another question, but I'm sustaining the objection.
When you got back in your car and you were going to leave, where were you going?
After that, I believe I was in the car wash.
That's why we don't leave.
Honestly, I don't remember.
Yeah, I know, because before you said you didn't. Go ahead. It's okay.
I don't have any further questions, Judge.
I
Well, hold on. You don't have a question.
When you get back into your vehicle and your sister's in the vehicle, you're going to leave, correct? Well, no. Were you going to leave or not?
Yes.
Your friend has already come through the car wash, right?
Yes.
And at that point, you say you can't see your friend.
When I was leaving. Yeah.
Then how did you know he was still there?
I mean, I couldn't see him, his person, but I could see his car. Like if I look back, like out of my window, I see his car still parked. But where my friend was, I didn't see. Like if he was outside the car, in the car. Because when I was finishing up vacuuming my car, he was wiping from the car wash.
So at the point in time that you and the defendant are exchanging greetings, you're about to leave.
Yes, because after that, I confirmed that the law.
Okay, and so where was your friend at that moment?
At that moment, when I got out from my vehicle, law was inside.
No. Because you gave him the finger, whether first, last, or in the middle. while you were still in the vehicle, right?
Yes.
And that was after you had vacuumed your car.
Yes.
And so you were leaving after you vacuumed. So you were still in the vehicle.
Yes.
Where was your friend?
It was still parked in the lot, the vacuum lot.
And you're saying you could see his vehicle but couldn't see him.
Yes.
And so after you two exchange pleasantries and you're about to leave, why didn't you just leave?
Well, that was the point where he was pointing the gun at me.
He didn't point the gun at you till you got out of the vehicle. At the point before you got out of the vehicle, why didn't you just leave?
Because I wanted to make sure that the law was leaving with me as well.
So there was nowhere for you to pull in the entrances or exits and get on a cell phone?
I could have, but that's in a thought.
In fact, you could have pulled down on one of the driveways and waited, right?
I mean, yeah.
No, I mean, from practical, you could have, right? And then waited for your friend to come behind you, right?
Well, I mean, I didn't know if my friend would have exited his vehicle because Jabril at that point, before I got down from my vehicle, Jabril had already parked and exited his vehicle. So I don't know if my friend got out from his vehicle as well. So out of concern for my friend as well, I wanted to get out from my vehicle and make sure that everything was okay before I left.
Any questions based on the court questions?
None for me, Your Honor.
Testify when I question you that Talal and Jabril did not have an issue with each other. The issue was strictly between you and him and your family and the Shawakas.
Talal was aware of the situation that was going on.
You mentioned to the judge that you said they told you the Range Rover, another vehicle, and you named some people were there. Who is they?
Talal told me that the Range Rover was.
Hold on a second. Did you see these or did?
I did, yeah.
Do you know who they are, or is the only reason you know who they are is because of what somebody else told you? Not going to allow the answer.
Thank you. On the day of this incident at the car wash, your sister was still living with Thebe Shawaka at the Roundtree address, not at your house.
No.
She had moved out.
Yes.
Yeah. When Talal came out of, and this is my last question on this Talal and where he was. When he came out of the car wash, he went to the vacuums and you were exiting. So Jabril had passed you coming in and you were going out because you were driving, correct?
Yeah.
And you chose not to keep going onto the service drive, but to turn around and go back into the car lot, into the car wash, correct?
No.
Okay, nothing further.
Nothing further, Your Honor. Thank you.
You may step down.
Thank
We call you next witness.
People call Talal Almeida.
This witness be excused. He's remaining in the courtroom, the past witness. Do you have any objection?
He can be excused.
All right, stay in the courtroom.
Oh, Your Honor, with in anticipating that this may go to trial, I would like him to be excused from the court.
I'm not going to excuse him for that reason.
Good afternoon.
Need the interpreter sworn.